1.
Good morning, ladies and gentlemen. Welcome to the August 2025 meeting of the Board of Oil, Gas, and Mining here in Salt Lake City. We're going to proceed on to our briefing section, and I'm going to turn it over to our director, Mr. Thomas.
Thank you, Chairman and members of the board. I appreciate your time today, especially given the traffic. I'm glad everyone was able to make it in. It was a 55
It was touch and go.
Right, it was, and we could talk about that for a while. We actually have a fairly robust amount of information to cover this morning in the briefing session. I'll try to be as concise and quick as possible, but please, I'll give breaks so questions can be asked, and we're welcome to have broad discussions about any one of these. First, I want to give a summary update on where we are with the oil and gas bonding. As all of you know, and many of the folks in the audience, this year has been very, I would say, relatively busy compared to other years as we work through the oil and gas bonding modernization. We have developed a number of drafts, the second one being probably the most robust. That second draft was provided to the public, and comments have been received from industry and other stakeholders. Our staff right now is reviewing those comments. I will say that generally I don't see large substantive changes that would then be put into a third draft. That said, there are going to be some things that are corrected and resolved in this third draft, but we hope to have that available. Well, I would say I'll commit. We will have that available before the September board meeting, if not sooner. We just have to get together and compare our comments and make sure we all have a good understanding of that. We are still on track to provide a good draft to the board that you all can then take, evaluate, and choose next steps with the hope, and this is just a hope, that we're able to initiate at least formal rulemaking before the end of the calendar year. I'll put that out there. You're welcome to say, I don't know, Mick, but that's tentatively where I think we could be. So there's our update on the oil and gas bonding rules. Before I move on I know that's a topic. Before I move on, is there any discussion or questions you have regarding this?
Looks like we're good.
Okay, very good. Thank you so much. Second, some update on the legislative building blocks request from the division. Every August, really every summer, we work together to evaluate what are the needs of the division. Are there any areas where we would need additional funds to support, our mandate in the board, additional people to provide services? Traditionally, even with my predecessor, building block requests have been very, very conservative. And that continues. The division is very thoughtful in the fiscal conservatism of state funds, especially in light of the legislature's desire to be careful. They've called it a socks and underwear year. At the same time, our oil and gas industry especially has nearly doubled in the past 5 to 6 years. The amount of work that the division needs to do to support that industry has increased, not proportionally, but significantly. Also, with the increased focus on maintaining and revitalizing our coal program in the state, as well as the focus on metal mining, specifically critical minerals that we've seen from the national administration all the way down, the division has proposed a building block request for, I think, 5 to 7, I'll look at it, new FTEs to meet that demand. Our staff right now, honestly, are highly intelligent and hardworking people. That skill and that dedication, well, covers a need sometimes, masks a need that when you dig into it, you realize, well, if we're going to sustain this growth, which it looks like we will, at least for the next, few to maybe 5 to 7 years or more, we need some additional staffing to support the industry or things could start. I don't want to be the bottleneck, is what I'm saying, as far as industry growth goes. We're also moving forward to ask for additional funds to cover those staff. Approximately $1.6 million to cover staffing and additional operational needs in the division. Those are some of the larger ones. The third one, as we continue to modernize the data we provide, that takes money. And the state especially, the division, provides a data set and a service that isn't matched or can't be found anywhere else. Operators especially come to the state and say, what's going on statewide, because they're able to make business decisions off of that. And those data sets are critical, and we're moving in the division from, frankly, a file cabinet Excel spreadsheet sort of format to a much more user-friendly cloud-based format. That's been something the division's been doing with Salesforce for a few years now. It's gone over very well. Salesforce as a company is used in other agencies. The governor's office uses it. Department of Environmental Quality uses it. We use it in different aspects here in the Department of Natural Resources. So it's definitely not OGM specific. But in talking with Salesforce, talking with with our DNR DTS team, they provide a great product at a very good price. And that's what we've seen over the past few years. We do have a building block request to cover any additional funds as we move toward e-permitting for the oil and gas side especially, as well as record and data management. That's going to be an ongoing work. I'm happy with the direction that we're headed on that, though. A few smaller requests, data backup and preservation. We have a small request, relatively small by state standards, of about $40,000 to cover a data backup and security. I'm butchering this. I know the person who put it out is like, oh my gosh, Mick. But anyhow, a data backup platform. And we're also acquiring a new drone because the federal government has determined, rightfully, that surveys and work involving federal land should not involve drones that are made overseas, specifically China and some other nations. This mandate from the federal government that we use domestic sources for drones comes with a cost. It's about 3 to 4 times higher to have a domestic drone versus one made, let's say, in China, 20,000 versus 60 versus 80, but it is what it is. And since that's mandated, we put in a building block request to cover those. Any question on the building blocks specifically?
I'm just curious what happens with all the old DJI drones.
That's a good question, Chairman, Commissioner Moon. The drones that we have that are still functional are being either sold at a pretty good price or shared or given to sister divisions within DNR. Like wildlife doesn't have that mandate where they're doing the sort of regulatory stuff that we are with drones, and so they're able to take advantage of that equipment. It's amazing. A drone's retail value isn't anywhere near what it's kind of like a car, right? It's funny. It seems to still be working, but it's comforting at least to know that we can support our sister divisions within DNR with equipment they need. Any other questions?
Yeah, just a comment, I guess, more of anything. We're seeing $1 billion in research that's being offered by the federal government on critical minerals. So be aware that that's happening on our side at the university and research or industry. So there isn't a lot of skill set out there in critical minerals. Your fine folks here are probably going to get poached. So going after those 5 to 7 FTEs is a good start, but just be aware it might not be enough. Make sure you got a little in the kitty for high performers that you need to retain. Thank you.
Thank you. Chairman, Vice Chairman, Mr. Walker, we are well aware of that. It's fascinating to have been following and frankly actively engaged in how critical minerals are developing in Utah specifically. I late last night drafted white paper for one of our groups outlining that. Staff-wise, if it was just about dollars, we would have lost a lot of great people. It's important to give a good, holistic, healthy environment for folks to come to, where there's a certain amount of job security, freedom, and a feeling of accomplishment. I hear that in our staff consistently, and it's very rewarding. I'll still say, I said it this morning, our staff is among the best, if not the best, I've ever worked with. They're highly skilled. And the Utah development of critical minerals is across a number of agencies, not just the universities. The governor's office, the legislature, many of the divisions here in the Department of Natural Resources are actively working with industry to make sure that Utah is perfectly placed to take advantage of those funds and the quick near development of critical minerals. So thank you for highlighting that. Any more questions on building blocks?
I think we're ready to move on.
Thank you. Last week, I presented to the Joint Natural Resource Committee on the one big, beautiful bill that was put into law on July 4th, 2025. And it's that bill, actually, the division in the industry is in a wonderful place because of that bill. Some other folks in other divisions maybe aren't too happy about it, just because of the changes involved. But it definitely it indicated a shift on the federal side toward a pro-growth attitude for oil, gas, and mining, really for extractive industries. That bill mandated shorter timelines, and honestly, in some cases, the first timelines for some of the permitting and work that's being done by our federal partners on the mining front, as well as oil and gas. That bill opened up a significant amount of federal land to oil and gas development. And really, it's interesting if you look at the bill and you evaluate it. In many ways, it was groundbreaking, but when you just look at the numbers, it really reversed, not surprisingly, a lot of the policies that we've seen in the past 10 to 12 years. It's not a bill, frankly, that took us back to 1970 or 82 or anything like that. It turned back many of the regulations that, to be candid, were a bit lopsided against the extractive industries. And as a supporter of the board, we can say that objectively. The bill continues to provide support for oil and gas. And as you mentioned, that $1 billion for critical minerals and stuff and items, the administration recognizes the need for domestic security in energy as well as technology, and the bill it was a bold step to move us in that direction. Definitely it supports Utah in some critical ways. It provides some security, long-term planning ability for our oil and gas operators. It also, I think, may have been considered in some places a lifeline for our coal industry that has really been, well, frankly, struggling compared to where they were 20, 30 years ago. And as Vice Chairman Walker indicated, the focus on critical minerals, especially on a domestic and security front, is nothing to sneeze at. It's a significant and needed move, frankly, because the ability to defend ourselves is critical to the support of our financial, cultural, and social environments in the U.S. So the bill was strong. The Utah, it was, especially on the permitting front, I found that it actually aligned with with the primary direction that we've been moving in this spring and summer, and that is to evaluate permitting processes and say, where are opportunities for streamlining without compromising any of the environmental law, without compromising any laws that protect Utahns, but how can we just do things simpler and faster? And so it was good to see that sort of maybe unintentional or intentional cooperativism between Utah and the federal partners. Any questions? I do have a little bit more on that, but I want to at least open up any questions you may have about the bill.
In talking with the industry folks here in Utah and with the feds, are you seeing the feds taking advantage yet of a lot of the things in that bill? Are they changing policies and doing things? It's fairly new, so I don't know if you're seeing any changes in the field yet or not.
Well, let me try to keep this under an hour, okay?
Please.
That's a little bit of a joke. I want to say in the states I've worked in, our federal partners, not just in Utah, in Idaho, and even in Hawaii, are really pro-state. The regional folks especially are very pro-state. And when our staff works with them, they're on the same page. They want to be quicker and provide better customer service to, well, frankly, to the folks who have the industries to support our tax base, right? They understand their role. So I would say yes to your question, Chairman. On Monday, several members of our staff met with several members of the Bureau of Land Management staff, including state senior leadership, for about 4 hours. And we talked about ways to collaborate on, frankly, predominantly permitting mechanisms to help them be quicker and to help us be quicker and to eliminate as much of the duplicity as possible. That's a huge endeavor, right? And you can't come at the whole thing all at once, but you find small little moments, small little first steps to start down that path. Because if we can take a 3-year cycle or a 5-year cycle and take it down to 2 years or 1 year through combined efforts, that's a win. That's a win for industry, and it sets Utah apart from other states because it provides a more favorable near-term environment for oil and gas and mining to develop. It was very good. I went into the meeting with high expectations, and our staff on both sides really delivered. We're going to have next steps that come out of that as we continue to work with our federal partners to look for ways to definitely consolidate permitting. There's some discussion about how we can work together on bonding requirements. So generally, there were no no's in the room. It was, how can we make this better?
Yeah, for several years, a lot of the major decisions ended up being made by Washington, D.C., which really slowed things up, and people who are not familiar with the local issues. And hopefully a lot of that decision-making will be returned to the states for their own little areas to see what works in different areas.
Chairman, you brought up a good point. In the conversations that we've been having with our federal partners, and I've seen this throughout my career, my recent career especially, the actual laws and policies, if they are interpreted at face value, really aren't problematic. I'll even say that NEPA is not necessarily problematic if you simply follow the directions written on the paper, right? I think, and I do, it is my observation, the amount of caution in decision makers goes beyond what's written in these laws, in these policies. They've tended to be hesitant because of the risk of litigation and the risk of political fallout. So having support from the current administration as well as the state to say, make the right decision and we'll stand behind you, really does a lot to enable these folks to start moving things around.
Thank you. Board, do you have any other questions or comments? Mr. Church.
I don't know whether this is appropriate at this time, but I just wanted to get the status on our application for primacy on the Class 6 wells. Is that coming along, or do you have an estimate of how long that will take?
I could be wrong in answering this. I will say my belief is it's been shared with the governor's office for that letter to be signed and moved forward. The work at the divisions level has been completed. So it's close. I'm try to be careful there. We just have to push it a little bit, but it's very close. Thank you, Chairman.
Board, do you have any other questions? Think we're ready to move on.
Thank you. Thank you very much. Some other items. I actually did talk. Okay. Last week, 2 weeks ago, we had a series of interviews for the oil and gas deputy director, and the hiring panel was myself, OED director Emmy Lasovsky, and my supervisor, DNR deputy director Nathan Schweibach. And we interviewed, I'll just say, 5 candidates, and we are evaluating each of their criteria now and ranking them. It was a pleasant challenge to have because each candidate wonderfully was well qualified. And each of these candidates brought skills and qualities and institutional knowledge and ability and even personalities that were great, but yet very different from the other 4. And because of that, we want to make sure, how do we really compare the candidates we have? And it's been a process. I appreciate the help of Ms. Lasovsky and Mr. Schweibach in this. We hope to make at least have a formal or informal recommendation within the next 2 to 3 days as to who that deputy is going to be. And depending on the candidate is going to have a lot to do with when that start date's going to be, right? I do say we do plan to have a candidate in the role by at least November 1st, if not sooner. That's what I can offer you there.
Great.
Thank
Good
you.
news.
Yeah, it is good news. It is really good news. The oil and gas program especially has churned along very well, honestly, because Bart Kettle, while he's moved to the field, is still just so helpful in handling so much of the day-to-day for those programs. I could say more. I'm not going to. You know how he is. He's very solid.
He is. He is.
Any other questions?
Think we're ready.
All right. Well, that actually went a lot faster than I thought it was going to, but good. Next month's meeting is going to be on Wednesday, September 24th in Vernal. I will not be at the September Vernal meeting. I am going to be at the Interstate Oil and Gas Compact Commission Conference, which is scheduled that week. I'll have to let them know that was a terrible scheduling conflict and not to do it again. It actually is a little bit abnormal. They normally go for the first week of October. And then I am likely going to be tentatively out of the office again for the October meeting on a potential trade mission with Governor Cox. At both meetings, Dana Dean, our deputy director, will be there and happy to move those meetings and answer any questions you may have during those times. The most important part is I do not want the development and introduction of the oil and gas bonding rules to be delayed by my absence. So we're going to work closely with the board and our staff to make sure that you all have what you need when you need it to make decisions moving forward. The good thing is the division can move along very well not too well without me, but can move fairly well without me.
Let's not say that.
Let's not say that, right. Just strike that from the record, Matt. Anyway, that's what we have there. And any questions, I guess it comes to public comment.
Seeing none, do you have anything else, Director Thomas?
I do not.
Thank you. We now have an opportunity for public comment. If there is anyone in the audience who'd like to speak to the board, please come forward. Is there anyone online who'd like to interject any comments?
I do not see any online.
Thank you. Seeing none, I think we'll move on. Thank you, Director Thomas. I would just like to thank everyone who made it through the traffic this morning to get here. We were concerned we might not have a quorum by 9, but it's working out. I think we're ready to proceed, everyone. We're going to move into the formal part of our session now. We'll give the attorneys a second to get set up. While they're getting set up, let me let me just explain, we're going to mix up the agenda a little bit. We're going to put both of the Middle Fork items together so you can do 1 and 2. Then we're going to move on to the Perchetti matter, and we will end up with the formal rulemaking on the mining rules, just to kind of give you a heads up and as we're changing things around here. Mr. McDonald, I'll go ahead and read this docket into the record. This is docket number 2025-027, cause number 470-18. In the matter of the request for agency action of Middle Fork Energy, UINTA, LLC, for an order establishing overlapping special stand-up drilling units for production of oil, gas, and associated hydrocarbons from the combined Wasatch through Dakota Formations from long lateral horizontal wells in sections 25 through 28 and 33 through 36, 8 south, 21 east, S.L.M, and sections 30 and 31, 8 south, 22 east, S.L.M, and sections 1 through 4, 9 south, 21 east, S.L.M, all in Uintah County, Utah. This matter was continued from the June board hearing. Do I do her first? Okay. Mr. McDonald, would you like to state your appearance of counsel?
Yes.
Are you ready?
I am.
Okay.
Fred McDonald of counsel with Lear & Lear on behalf of petitioner Middle Fork Energy, UINTA.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
And we have Ms. Dragoo here at the respondents table. Would you like to state your reason
Yes.
for being here?
Denise Dragoo, and I represent Greylog Production.
Thank you. Mr. McDonald.
Thank you, Madam Chair. With me today testifying on behalf of Middle Fork are Ms. Allie Schuster, the landman, and also virtually pursuant to the board's order entered on August 22nd, we have virtually Mr. Ken Babcock, the geoscience manager, and Mr. Rob Zabak, the reservoir manager. And I would ask Mr. Vice Chair to swear them in at this time.
Please raise your right hand. Do you swear that the evidence that you're about to give on this issue is truth, whole truth, nothing but the truth? So help you God?
I do. I do.
Gentlemen, do you, can you state that on the record, please?
I do. I do.
Thank you. The resumes of all three witnesses were provided collectively as Exhibit A as supplemented. If separately asked, each would verify the contents if their resumes are true and correct. Ms. Schuster will be a fact witness only. Mr. Babcock and Mr. Zabak have been previously recognized by the board as experts in geology and petroleum engineering respectively, most recently in cause numbers 470-10 and 475-11 respectively. Presuming the division has no objections and based on their resumes, we would ask that they again be so recognized as experts in those particular fields for purposes of this cause.
Division.
Yeah, no objections from the division.
Board. They're so recognized.
Thank you. As the board is aware, this matter has been continued 3 times in order to allow Middle Fork and Greylock Production LLC to work out some issues between them. As a result, Middle Fork has agreed to eliminate the 2 drilling units designated as B and D in the request for agency action, and will at a later time seek spacing of them through the filing of a new request for agency action. Consequently, we are moving at the beginning of this hearing to amend the request accordingly and ask that the board rule on that motion before we commence with our presentation in chief.
Division, do you have any comments?
Yeah, the division is fine with that.
Board, do you have any questions or comments? Mr. Greeley, do you have any comments?
Just on behalf of Greylock, we support the motion. Thank you.
Thank you. Hearing no objections, it's so amended.
All right, and if the board would keep in mind, as the exhibits were filed before that stipulation, they'll show a B and D, but they are not going to be part of this request today.
Thank you.
All right, I also want to confirm that the board received the supplement to Exhibit D filed last Wednesday and the supplement to Exhibit Z, which is just the certified mailings on Monday.
Yes.
All right, thank you. And finally, again, I will be moving for admission of all of our exhibits at the end of our presentation in chief.
Thank you.
Members of the board, Middle Fork is before you today seeking establishment of now just 3 stand-up drilling units for the production from the Wasatch through Dakota Formations as defined in the request for agency action via long lateral over 1 mile in length horizontal wells located within Township 8 South, Ranges 21 and 22 East, Salt Lake Meridian, Uintah County, Utah. These will be overlapping drilling units for long lateral horizontal wells. Middle Fork seeks to drill up to 4 such wells on each of the 5 benches, which are the Wasatch, Mesa Verde, Black Hawk, Mancos, and Dakota, in the space formations within each requested drilling unit. In other words, a total of up to 20 for each drilling unit, subject to the various caveats outlined in the request and in which the board has imposed for other authorized long lateral horizontal well drilling units in the basin. However, this requested action may require the partial vacating of 6 board orders insofar as they pertain to the lands within and to the extent inconsistent with the requested drilling units. Specifically, the board's orders entered in cause numbers 173-15, 173-16, 173-18, 173-19, 173-23, and 187-09. True and correct copies of those 6 orders were collectively submitted as Exhibit B in this cause. The board has jurisdiction over this matter pursuant to Utah Code Sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was provided to all production interest owners within the requested drilling units, to the Bureau of Land Management, Bureau of Indian Affairs, and the School and Institutional Trust Lands Administrations, being the oil and gas owners, lessors, and agencies having jurisdiction over development, via certified mail return receipt requested. The mailings were sent to the last addresses disclosed by those agencies and the Uintah County Realty records, as well as the Middle Fork's internal records themselves. The record will also reflect that notice was originally duly published in the Uintah Basin Standard in the Vernal Express on April 2nd, 2025, and in the Salt Lake Tribune on April 6th, 2025. The matter has been continued 3 times, but no additional published notice is required under the board's regulations. The division filed a response on April 9th, 2025, expressing non-opposition, presuming Middle Fork meets its burden of proof by providing sufficient evidence at hearing justifying the drilling of these long lateral horizontal wells in the drilling units without committing waste or adversely affecting correlative rights. As today's testimony will reflect, these conditions have been met. No other formal objections or responses were timely received, and with the amendment to the request for agency action approved earlier, the matter is now uncontested. With that, I'll commence my examination of Ms. Schuster. Ms. Schuster, would you please state your name and business address for the record?
Allie Schuster, 1401 Winecoop Street, Suite 300, Denver, Colorado, 80202.
And what is your current position with Middle Fork, and how does it relate to these drilling units?
I'm a landman with Middle Fork, with concurrent supervision over all land matters involving these DSU and the land records thereto.
All right, would you please state for the record the corporate and bonding status of Middle Fork?
Middle Fork is a Delaware limited liability company in good standing with its principal place of business in Denver, Colorado. It's a wholly owned subsidiary of Coda Holdings, LLC. Middle Fork is duly qualified to conduct business in Utah and is fully appropriately bonded with all relevant federal and state and Utah agencies. And CODA shares its personnel with Middle Fork.
All right, thank you. I'm going to show you now what have been marked as Exhibit C. D is supplemented, and E through G. Do you recognize those exhibits?
I do.
Were they prepared by you or Middle Fork personnel with your review and input?
Yes.
All right, starting with Exhibit C, would you please explain to the board what this shows?
Yeah. Exhibit C is a regional locator map reflecting the general location of the requested DSUs. They're approximately 25 miles due south of Vernal. The DSUs are proposed for development in the area between two federal units, the Wasatch Valley unit and the Natural Buttes unit.
All right, now I'm going to turn your attention to Exhibit D, starting with the first page. Would you please explain what this shows?
Yes, Exhibit D shows the proposed drilling and spacing units, A through E. As discussed earlier, B and D have been removed, so A, C, and E are the DSUs subject to today's application. Drilling Unit A is located in Township 8 South, Range 22 East, S.L.M, Sections 30 and 31. Drilling Unit C is located in Township 8 South, Range 21 East, S.L.M, Sections 26 and 35, as well as Township 9 South, Range 21 East, S.L.M, Section 2, Lots 1 through 4, and the south half of the north half, which comprises the north half of Section 2. And then Drilling Unit E is located in Township 8 South, Range 21 East, S.L.M, Sections 28 and 33, as well as Township 9 South, Range 21 East, Section 4, Lots 1 through 4, and the south half of the north half, as well as which is essentially the north half, and then north half, south half.
All right, now turning to the second page, which is the supplement, would you please explain what this shows?
This just shows the ownership within these units. So the three units we're looking at today, DSU A is combined of fee, fed, tribal, and state. DSU C has federal, fee, allottee, tribal allottee, and tribal minerals. And then DSU E is a combination of federal and tribal allottee minerals.
All right, what is the experience that you've had with Middle Fork with respect to communization agreements with the federal and Indian lands?
When federal and Indian lands are present, we need a communitization agreement for the DSUs.
And generally that requires a state order or an order from the board creating spacing units.
That is correct.
All right. Now turning your attention to Exhibit E, would you please explain what this reflects?
Yes. Exhibit E shows the ownership within the units. Middle Fork and its sister affiliate, UINTA LLC, which is also a wholly owned subsidiary of CODA Holdings, own the majority ownership in each of the requested DSUs. So we're showing our working interest combined between Middle Fork and Karis, and then we're showing what the partner working interest is in each of the DSUs.
And clearly, you're in charge of the majority of each of the three.
Combined, we are the majority owners, yes.
All right. Now, turning your attention to Exhibit F, would you please explain what this shows?
Exhibit F shows the current spacing orders that are associated with the lands in the subject of these DSUs. Let's see, case 173-16 is associated with the Wasatch Mesa Verde located in DSUs C and E. 173-18, Wasatch Mesa Verde associated with DSU E. 173-19, again, covers the Wasatch Mesa Verde formations within DSU A. 173-23 covers all three of the DSUs. 187-09, again, Wasatch Mesa Verde within DSU A. All of these orders contemplated development on a conventional vertical or directional drilled well basis. And so Middle Fork now desires the ability to also develop these lands through horizontal wells. So we would like to request that these DSUs are overlapping and pertain only to the horizontal well development, and that production from existing wells remains on the basis of these existing orders. And correlative rights will be protected by the proposed setbacks from the existing wells, as Mr. Zabak will address later in testimony. And we would like these orders partially vacated to the extent inconsistent with today's request, but we would like to note that these will be overlapping.
All right, now I'm going to turn your attention to the certificate and supplemental certificates of service These are pleadings already on file in this cause that were prepared by my office. Do you recognize the names and addresses that are shown on them?
I do.
And who are those parties and how are those addresses derived?
These are the interested parties within the drilling and spacing unit associated with today's application. And they were derived through our internal records and through searches of the Utah records online.
For the agencies?
For the agencies.
Yeah, and as well as the Uintah County records?
Yes.
Okay. And again, the Exhibit Z is supplemented, reflects the return receipts that were received by my office for the mailing. Either the return mailings were undeliverable or the postal inquiries as to their status. With that, that concludes my examination of Ms. Schuster.
Yeah, just maybe a clarification. So the request is asking, so there we can see the prior orders. So we're asking that to the extent they're inconsistent with this request, we'd like those vacated. But these are overlapping units. So I'm just trying to understand what would be inconsistent here.
Well, first of all, that it just talks about the, if my answer,
Okay.
that the orders cover the whole formation. Okay, so
Okay.
that's number one. Number two is if there's any setbacks that are set in there as far as wells without specifying that it's long lateral horizontal wells. So you're right in that they should be able to develop under these existing orders if they do a vertical or directional well, but we just want to make sure that there's no inconsistency with this request with those orders.
Okay. Just from the division standpoint, they have a lot of issues when we do have orders that cover the same sections. Just trying to understand which well is in which area. Are you aware of any of these that do also cover horizontal development at all, or
No.
are these all just direct?
These are all old ones.
Vertical. Okay. So I mean, the division would just request. I mean, we don't have any problem with that, but just if there is a specific thing that we are aware of, that we make that in the order, just to make it easier for the division when they're permitting these. We'd appreciate that. Just one other question. Greylock was here, the engineering appearance. You indicated that Middle Fork, Coda, Karis, you're the majority working interest owner. Could you just help us understand what was Greylock's interest in these lands?
Yes. Can we go back to exhibit? Let's go to the supplemental D, or yeah, that one's fine.
Okay. Which one? This one?
Yeah, that one's fine.
This is Exhibit E.
And most of these DSUs, Greylock is part of the partner working interest.
Okay.
And so in particular, the two DSUs that were removed, they have a majority of that partner interest, and they would just like to have further discussions on how we choose to develop these lands.
Okay, great. Thank you. No further questions.
Yeah, I'd like to get clarification on your intention on declaring these as overlapping. Now we have different orders, so these are going to be these new requests for agency action will be going across all of those different previous orders. Okay, now what about B and C? Now, are we going to come back and address that another time? Because if we're looking for a 660-foot setback, that's leaving a lot of property there.
The goal is that we are able to come to terms and agreement with Greylock and come back to you with the spacing for B and D at a later date.
Okay. All right, thank you.
Could you go back to F? Just in looking at the map, orders 173-15 and 18 only cover B and D. Are you wanting to amend those? Since those have been withdrawn, are those included in your order today?
18 also affects the south half of Section 4, so that should be an E. Did you say 18, Madam Chair?
Yeah, A, B, C. Oh.
Yeah, so
okay.
the south half of 4.
Okay.
Yep.
Okay. 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 Are you wanting 15 then included amendments to that?
No, I'm sorry. 15 should not be included in that
Okay, so you do want to
Yep.
leave 18 in but take out 15.
Right.
Okay. That's all I have. I think we're ready to move on.
All right, thank you. With that, I'll
Just
commence.
one second.
Oh,
Oh.
I'm sorry.
There is a part of 15 in the Unit A.
I believe
That's a
that's
different
actually
color.
173-19. I
Similar.
apologize. On these screens, it looks
Kinda
very
close.
similar. It doesn't look
Yeah.
that similar on my screen in my office. I apologize for that.
And then one quick question. So Greylock's concerned with, they are owners in these units. Yeah, they're not adjacent, contesting setbacks or anything. It's just,
They do also own adjacent lands, but their particular concern was within the DSUs, so we're working with them on that.
okay, yeah, because there was no response from them that we saw. It was just you guys working
It was
out.
just internal matters, yes.
Okay.
Do we have any other questions? Now I think we're ready to move on.
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Babcock. If we could have the IT people bring him up, please.
Stand by.
Thank you. Mr. Babcock, would you please state your name and business address for the record?
Yes, Ken Babcock, 1401 Wincoop Street, Suite 300, Denver, Colorado.
And what is your current position with Middle Fork, and how does it relate to the drilling units at issue today?
I'm the geoscience manager, so I supervise and work on all of the development of our UINTA asset.
All right, I'm assuming you have these exhibits in front of you, and hopefully you can see the PowerPoint that I'm presenting here in Salt Lake. I'm going to show you exhibits G through I. Do you recognize these exhibits?
Yes, I do.
And were they prepared by Middle Fork personnel with your review and input?
Yes.
All right, starting with Exhibit G, would you please explain to the board what this shows and its significance to today's hearing?
Yes, Exhibit G is showing the type log from which the stratigraphic definition of the space formation is derived. You can see the wells located in section 27 between DSUs C and E. The primary objective of the proposed drilling units is a thick package of sandstones compromising of the subject formations. The earlier tertiary Wasatch Formation is composed of a sequence of sandstones, siltstones, and conglomerates deposited in a fluvial to alluvial dominated system. Below the Wasatch is a late Cretaceous Mesa Verde Formation, which is comprised predominantly of interbedded sandstones, siltstones, and carbonaceous mudstones and coals deposited in a fluvial to coastal plain dominated system. The Blackhawk Formation is composed of alternating sequences of marine sandstones and shales. Marine Mancos Formation underlies the Blackhawk Formation. The Mancos Formation is predominantly a deep marine shale sequence that interfingers with shoreline sandstones to the west. The Dakota Formation is the final late Cretaceous shoreline that is deposited in a deltaic to shoreline depositional setting.
All right, now turning your attention to Exhibit H, would you please explain to the board what the significance is to today's hearing?
Yes, Exhibit H is showing the potential lateral targets. And on the left, you can see we're highlighting the, I don't see it on the one on the screen, but the Neslin and Blackhawk formations, which are two of the targets that Middle Fork has been drilling in the Uinta Basin.
All right, now turning your attention to Exhibit I, this is a two-page exhibit. Let's start with page 1. And what does it show?
Okay, yes, this is showing the continuity of the formations across the spaced units. Yeah, there is continuity across the area, and it's favorable for horizontal drilling.
And the second page just is showing deeper logs.
Exactly, yeah, it's just extended to show all the way down through the Dakota, a little more in depth.
Okay, is it your expert opinion then that the formations that you're seeking to space constitute a common source of supply of resource?
Yes.
Is it also your expert opinion that these formations underlying the subject lands are continuous and favor long lateral horizontal well development?
Yes.
All right. Madam Chair, that concludes my examination of Mr. Babcock.
Division, do you have questions?
Division has no questions for Mr. Babcock.
Board, do you have questions? Mr. Moon.
May not be the right witness. It might be you, but explain the just the odd southern shape of the. Why do they end halfway through the section? You know, so it's like 2.5 miles. Some are longer, some are shorter. Just maybe explain why the shape.
Yes, can we go back?
Yeah, that's more of a land.
Yeah.
Okay, yeah, this is a great, this exhibit that we're showing, Exhibit D, you can see that the Natural Buttes unit boundary line is on there. It's in that black kind of dotted line that butts up to the bottom of the DSUs. So we're just taking it to the boundary of the Natural Buttes unit. And you'll see the river there. So our ideal location for surface development is on the northern side of these units. And so that's really the only way you're going to be able to develop some of that acreage because of the river.
Okay, and then on the northern side, we got the Wasatch Valley.
Yes.
What happens in between those?
So we are working with the BLM right now on steady expansions of the Wasatch Valley unit. The goal eventually is that these DSUs are just directly in between both units, but we're still in the process of that.
This is all BLM land, then surface?
This is largely tribal surface.
Tribal, okay.
Yes. But we are working that expansion of the Wasatch Valley. It'll just be kind of gradual right now per their requirements for that expansion.
Okay, thank you.
Yep.
Any further questions? I think we're ready to move on.
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Zabek. If we could have the IT. Yep, great. You're on it. Okay, Mr. Zabek, would you please state your name and business address for the record?
Yes, Rob Zabek, 1401 Winecoop Street, Suite 300, Denver, Colorado, 80202.
And what is your current position with Middle Fork, and how does it relate to these drilling units?
Reservoir manager over all of our Utah assets, which includes the stuff we're talking about today.
Okay, I'm going to now show you what have been marked as exhibits J, K, second substitute exhibit L, M, and N. Do you recognize these exhibits?
Yes.
Were they prepared by you or Middle Fork personnel with your review and input?
Yes.
All right, turning your attention to exhibit J, would you please explain the significance to today's hearing?
Yeah, so we're looking at a map of the units that we're talking about that Allie and Ken have been discussing. And then we have two wells, the GB16D and the GB3D, where we have FMI logs. On the right side of the map there, you can see the rose diagrams. What we're showing here is the natural fracture orientation of the rose diagrams. This is consistent with what we call borehole breakout, which gives us the maximum horizontal stress. And so you can see the maximum horizontal stress is north 7 degrees west. That is basically the way our hydraulic fractures will grow when we drill. And so drilling perpendicular to these or within like a 30 degree of that maximum horizontal stress is optimal for horizontal development across most horizontal plays in the U.S. And so that's why these are stand-up north-south units.
Right now, turning your attention to Exhibit K, would you please explain what this shows and its significance to today's hearing?
Yes, so a little confusing here. What we have is a top-down view on the left and then kind of looking into the well bores on the right. And this depicts our proposed setbacks. We're looking at up to 4 lateral horizontal wells to be needed in each bench within each drilling unit. So Wasatch, Mesa Verde, Blackhawk, Mancos, Dakota that we're discussing today, provided that the producing intervals may not be closer than 660 feet, which you see in both depictions from the unit boundary, and no closer than 1,320 feet laterally from each well, drilled in the same productive bench. We've also proposed setbacks of 200 feet vertically from any other horizontal well to prevent drainage vertically, and then no closer than 200 feet both vertically and laterally from existing perforations within. There's several vertical wells that were drilled in different zones for these, and so that would be the setback from vertical wells, and that's just to protect correlative rights for those people that are being kind paid on a lease basis, they'll obviously still get the payment on a horizontal basis, but just to protect their correlative rights on those vertical wells.
Okay, now turning your attention to second substitute Exhibit L, please explain what this shows.
Yeah, I think showed this board several times. This is our rate transient analysis. We've used production data from the dozen plus horizontal wells we've drilled within the area, in addition to our microseismic data, to build out this model. And so you can see on the right there is basically our history match for the model. And then on the left is what does this look like from a drainage standpoint. And so you can see with a 660-foot setback, looking at effective fracture drainage after 5 years here, you can see your maximum horizontal drainage is 750 feet, with your north-south drainage being more like 150 feet. This results in 350 feet of that kind of drainage across that. So you're protecting correlative rights because you're still 330 feet off of drainage after 5 years. And that's consistent with what we've seen in previous models.
Now turning your attention to Exhibit M, please explain what this shows.
Yeah, so here we're looking at just EUR, OGIP, and EUR recovery factor for the two benches, just to make sure this is technically feasible and makes sense from a drainage calculation. So I'm really just looking at the two main benches we've targeted horizontally, the Nez and Blackhawk. That results in about roughly 1,350 feet of net pay, 7% porosity, 50% gas saturation. So you end up with roughly 800 BCF, sorry, of gas in place, with our expected recovery of roughly 10 BCF per well, 80 BCF. So that's a roughly 10% recovery factor, which is consistent with tight gas plays across the U.S.
All right, and finally, turning your attention to Exhibit N, please explain what this shows.
Yeah, here we're just looking at do the economics justify this type of spacing with our AUR of roughly 1 BCF per 1,000 or 10 BCF per well. Expected well costs, our average working interest NRI, conservative oil and gas price assumptions. We meet our corporate threshold, so we're getting a 30+% rate of return and 1.7 DPI. So very strong economics for these wells.
All right, is it your expert opinion then that the fracture orientation in this area favors a stand-up orientation for these drilling units?
Yes.
Is it also your expert opinion that up to 4 long lateral horizontal wells are needed to recover resources from each bench of each drilling unit without waste?
Yes.
Is it also your expert opinion that the setbacks offer protection of potential offsetting drainage and therefore are protective of correlative rights?
Yes.
With that, Madam Chair, that concludes my examination. Mr. Zabek.
Thank you. Division?
Yeah, just a couple questions, Mr. Zabak. I'm wondering, so the request here is 200 foot setbacks from existing vertical directional wells, laterally and vertically. Is that from their producing interval, laterally or vertical? Is that correct?
Yes, both laterally and vertically, yes.
Could you just explain, when I go to, could you go to Exhibit L, please, Mr. McDonald? In your example here, you show a fracture half length of approximately 300 feet. So could you just explain, with that kind of fracture half length, how you feel that this 200 foot setback would continue to protect those existing wells?
Yeah, so while we will have the fracture half length going across that 300 foot zone, really we have vertical wells scattered so much throughout these DSUs that we basically could not drill without roughly a 200 foot setback. There would just be too many wells. And if you think about the limited drainage, you've seen our vertical program where we're drilling 30 plus wells per DSU, right? So we know that you're not fully recovering with the way it's been drilled, but it was drilled on much wider spacing. And so for us to be able to go horizontally, you really have to have a setback of roughly that 200 feet.
Okay.
If that makes sense.
Yeah. The second follow-up question to that, it's kind of a different angle, but with a 300 foot half length, you also have a 660 foot setback from boundary units. Is there a thought at some point you will come through to try to infill these? Why the 660 foot setback?
I would say right now we're just looking at conservatively. It's kind of the way we've set up our program is 4 wells per DSU. There's definitely potential that as we get further along in horizontal development, as I've testified before the board before, we're the only player on the gas side doing anything. And so our science is kind of us doing it on our own. And so as we test this spacing and get more comfortable, there is a chance that we come back and propose tighter density spacing, which would also tighten up the spacing on that 660 off of DSUs.
Okay. All right, no further questions. Thank you.
Board, do you have questions? Mr. Church?
On your program, do you anticipate commencement of this drilling program in the very near future?
Yeah, I mean, right now with where this is at, it will be a little further along, but just looking at our drill schedule just to the north in Wasatch Valley. So if we hop to the map, if you go to Exhibit J, please. So just north of the far western DSU that we're talking about here, about 2 miles north, we have a well planned for this winter. So we do plan on drilling that in kind of November. We'll be drilling it vertically initially to get pilot and logs. And then the idea would be come back and go horizontally in late winter, call it early 2026. And so pending the results of that, then we would look at developing this subsequently after kind of testing in that area. But these will be the first wells that Middle Fork has drilled in the Wasatch Valley unit. I will point out that we drilled a horizontal Blackhawk well just to the east. You can see the line on Exhibit J there. So we did drill horizontally just offsetting these DSUs last year.
Thank you.
Mr. Moon?
Question on your hill toe setbacks of 660. Do you worry at all that that's being overly conservative? Because on your hill toe you're leaving, well, according to Exhibit L, you're only reaching about 200 feet below your hill and toe and leaving 460 feet. Yeah.
No, I would agree. It's probably being a little overly conservative right now on the setback for north-south end of the unit.
Yeah, so perhaps after you drill a couple of these, then you'll be able to gather some data and extend those setbacks or shorten those setbacks.
Yeah, my expectation on our horizontal, and I think we've talked about this in the past, though, is as we get more of these under our belt and kind of operationally get more comfortable, then yes, I think across the board we would come back and try to tighten spacing both on that setback and on interwell setbacks.
Okay. Yeah, because I was kind of had the same question as the division on why only 4 wells, but you do have basically a line of 4 wells of existing vertical wells going across the section. They don't line up great, but you do have to hit between those. So that really only leaves you room for 4, correct?
Yeah, I mean, that's going to be your biggest issue here is just how do we, and I'm sure some of the Central Basin operators have dealt with it, but how do we protect the relative rights of the vertical wells, come in horizontally and develop it efficiently? And I would say we're just in the early stages of understanding how to do that. And we will definitely come back to the board as we get more knowledge of that and work with you guys on what makes the most sense.
Thank you.
Further questions? Seeing none, back to you, Mr. McDonald.
Thank you, Madam Chair. With that concludes our presentation in chief. At this time, I would move for admissions of Exhibits A as supplemented, B, C, D as supplemented, E through K, second substitute L, M, N, and Z as supplemented.
Did you include N?
Yes, M, N, and Z as supplemented.
So admitted.
Any objection from the division?
No objection.
All right, thank you. With that, I'll reserve my conclusive remarks after the division's made its statement.
Division.
Yes, thank you. The division, they reviewed this RAA as well as the exhibits. We've listened to the testimony here today, and the division has no opposition to this request by Middle Fork as indicated in our response. Thank you.
Thank you. Board, do we need to deliberate on this matter? Sorry.
No worries.
I'm ignoring you again.
It wouldn't be the first time.
Mr. McDonald.
No, that's all right, Madam Chair. No, we just, again, we believe that all the statutory and regulatory requirements have been met. Middle Fork has established its burden of proof. With the amendment of the request to eliminate B and D, we would ask that the board approve the request as so amended. And we also want to definitely thank you for your consideration to allow Mr. Zabek and Mr. Babcock to attend, to participate virtually, and to the IT people for arranging that as well.
Thank you. Thank you. Now we're down to making a motion.
Yeah, I'm ready to make a motion, but I have another just curious question here. Just gas wells? Do you get some oil out of these wells?
Yes.
Mainly gas. In this area, we get maybe 10 to 20 barrel per million of condensate. And so we do produce oil, but we're all gas until you get up to the Green River. And these are all 1950s, 60s water flood vintage oil. So the oil wells have been drilled in this area, basically.
Oh, so it did have oil before. Most of that's been pulled out.
Yeah. If you look at these, Chevron, Gulf drilled these units back in the 50s and 60s, started water flooding them in the 70s. And so this is really the first production from the basin on this part for the oil side.
Okay, but the oil was up higher, right? You're going deeper.
Yeah.
Gas,
so unlike on the Central Basin stuff, when you cross the Green River, the Wasatch goes from oil to gas.
Huh.
Our Green River is still oil, and so we still have some Green River uphole completion. We still do water flood optimization. We produce about 2,000 barrels a day out of water flood units in this area. That's the black wax. But the rest of our stuff is dry gas.
So what happened geologically that made that change so much? It's not very far over.
The quick transition across the Wasatch, I will leave that up to Ken or somebody smarter than me. I will say it's still up for debate across most circles. Now, Mesa Verde, when we get deeper, that's gas all the way into Central Basin and everything. But the Wasatch transition is something that I don't fully. Ken, you have something?
I would just say, when you hear about the Wasatch and Central Basin, it's kind of more of the lacustrine or kind of lake deposits that they're targeting, more oil prone. And a lot of the Wasatch gas development over Watson's Valley and Greater Natural Buttes is more fluvial sands that are probably charged by coals and things like that. So it's probably a change in the source rocks charging more gas prone, becoming more gas prone.
Okay, I just like to ask questions. Not that I understand the answer anyway, but so I would move that we approve this request for agency action.
I second. It's been moved and seconded. All those in favor, please say aye. Aye. Any opposed? In your order, would you please note that Board Order 173-15 is not included in this order?
Will do.
The matter is passed. Can we get you to write the order?
I will, and I'll submit it to both board and division council before submitting to the board. Thank you.
Thank you. Good deal. That matter being concluded, I think we'll go on and hear the second one before we break. So item number 3 is now becoming item number 2. This is docket number 2025-042, cause number 475-13. In the matter of the request for agency action of Middle Fork Energy Uinta LLC for an order modifying the board's order entered in cause number 475-02 to suspend Utah Administrative Code Rules R 649-3-2, R 649-3-10, and R 649-3-11, sub 1 and sub 2, as a result of the first expansion of the KJ2 federal unit to include lands within Township 6 South, Range 22 East, S.L.M, Uintah County, Utah. Mr. McDonald.
Fred McDonald of Counsel with Lear & Lear on behalf of petitioner Middle Fork Energy UINTA LLC.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Back to you, Mr. McDonald.
Thank you, Madam Chair. Again, testifying in this matter will be Ms. Allie Schuster, the landman, and also virtually pursuant to the boards entered on August 21st, Mr. Ken Babcock, the geoscience manager, and Mr. Zabak, the reservoir manager. If the board would prefer, instead of another swearing in, I'll just remind the witnesses that they're still under oath for purposes of this cause.
That'll be fine. Thank you.
All right. Again, all three witnesses' resumes were submitted as Exhibit A as supplemented in this matter. With Ms. Schuster, again, will be testifying as a fact witness. As the board is aware, Mr. Babcock and Mr. Zabak have been recognized as experts in geology and petroleum engineer. And with their resumes and with those previous recognitions, we would ask that the board again recognize them as experts in those fields for purposes of this cause, presuming the division has no objection.
Division.
No objection.
Board. So accepted.
Thank you. And again, I'll be moving for admission of our exhibits at the end of our presentation in chief.
Thank you.
Members of the board, as outlined in the request for agency action, Middle Fork is the current duly designated operator of the KJ2 federal unit in Uintah County. The unit is limited in depths below the lower Wasatch Formation. Pursuant to the board's order entered in cause number 475-02, the general well siting rules were suspended for the unit as provided in Utah Administrative Code R6492-3. Specifically, the 475-02 order suspended rules R6493-2 and R6493-11, subparagraphs 1 and 2. True and correct copy of the 475-02 order and of R6492-3 were collectively submitted as Exhibit B. Effective February 1st, 2021, 2,160 acres were added to the KJ2 unit, all of which are federally owned and all of which are fully committed to the unit. For some reason, there wasn't an addition of the suspension of those expansion lands back at that time. But now Middle Fork seeks to extend the 475-02 order as to those expanded lands. In the 475-02 order, the board already determined that operations conducted under the KJ2 unit agreement are intended to and do accomplish the conservation of oil and gas and the prevention of waste as is required under R6492-3. There are important caveats in the 475-02 order which will also apply to the expansion lands. Specifically, to protect correlative rights, Middle Fork continues to agree that no well may be drilled closer than 460 feet to a unit boundary or to an uncommitted tract, albeit there currently are none on the expanded lands, without an exception location approval by the division or the board. Also, Middle Fork agrees that the requirement to provide a directional survey as to any directionally drilled or horizontal well will remain in place. The board has jurisdiction over this matter pursuant to Utah Code Section 40-6, subparagraph 5.3b, and Utah Administrative Code Rule R6492-3. A copy of the request was sent via regular mail to all owners within the expanded KJ2 unit area, to the School and Institutional Trust Lands Administration, since there are state leases committed to the unit, albeit there are none in the expanded lands, and to the Bureau of Land Management, both to the state office and the Vernal field office, to their last addresses disclosed by the relevant agency in Uintah County Realty Records, as well as Middle Fork's internal records. Notice of the request of the hearing was also duly published in the Salt Lake Tribune on August 3rd, and in the Uintah Basin Standard in the Vernal Express on August 6th. On August 11th, the division filed a response to the request stating its non-opposition to the request, presuming Middle Fork meets its burden of proof at today's hearing, which we will. No other objection or other responses were filed, and no other party has made an appearance today. This matter is very similar to the ones that you've heard recently, in fact, involving this unit. With that, I'll commence my examination of Ms. Schuster. Again, would you please state your name and business address for the record?
Yes, it's Allie Schuster, 1401 Wine Coop Street, Suite 300, Denver, Colorado, 80202.
And again, your current position with Middle Fork and its relation to the KJ2 unit.
Yes, I'm a landman with Middle Fork with concurrent supervision over all land matters involving the unit at issue and the land records relating thereto. Middle Fork is the current operator of the KJ2 unit.
All right, and what is, for the purposes of this record, would you please again state the corporate bonding and status, the corporate and bonding status of Middle Fork?
Yes, Middle Fork is a Delaware limited liability company in good standing with its principal place of business in Denver, Colorado. It's a wholly owned subsidiary of Coda Holdings, LLC. Middle Fork is duly qualified to conduct business in Utah and is fully and appropriately bonded with all relevant federal and state of Utah agencies, and Coda Resources shares its employees with Middle Fork.
All right, I'm going to show you what had been marked as Exhibit C. This is Exhibit D, which there's no PowerPoint for, and Exhibit E. Do you recognize these exhibits?
I do.
All right, as to Exhibits C and E, were they prepared by you or Middle Fork personnel with your review and input?
Yes.
And as to Exhibit D, is this an official business record of Middle Fork?
It is.
Right. Turning your attention now to Exhibit C, would you please explain what this shows?
Yes. Exhibit C is the regional locator map showing the location of the KJ2 unit, which is about 18 miles south of Vernal.
All right, and again, Middle Fork is the duly designated operator of the unit?
We are.
Okay, now turning your attention to Exhibit D, would you please explain what this is about?
Yes, Exhibit D is the true and correct copy of the BLM decision letter dated October 26, 2021, approving the expansion of the KJ2 unit by 2,160 acres effective February 1st, 2021. And the expansion lands are all federally owned. It's 100% federal on the expansion.
And they're all fully committed to the unit?
They are.
All right. Now turning your attention to Exhibit E.
Yes.
Again, would you please show what this, please explain what this shows?
Yes. Exhibit E is the KJ2 unit Exhibit A map. It shows the expansion lands outlined in green to the northwest of the KJ2 unit. That's the 2,160 acres. It's all one lease. It's one federal lease. And then we've also noted that back in April, the blue outlined lands were withdrawn from the KJ2 unit at a UDOGM hearing and were added to the red wash unit with all the BLM requirements and approvals as well.
All right, and does the KJ2 unit, is it limited in depth?
It is. It's limited in depth below the base of the Wasatch.
All right, and again, there are no uncommitted tracks within the unit?
That is correct.
All right. Can you confirm for the record that Middle Fork will continue to operate under the principles set forth in the unit agreement, namely to maximize resource without waste as defined by state or federal law?
We will.
All right. We also confirm that you'll maintain the 460-foot setoffs, and as if applicable, will seek exception locations as required under the 47502 order.
Yes, we will.
All right. Now I'm going to turn your attention to the certificate of service in this matter. This is a pleading that was prepared by my office and is already on record. Would you do you recognize the names and addresses in that exhibit, and how were those names and addresses derived?
Yes, these are the names and addresses of the owners and overriding royalty owners within the KJ2 unit, and they were derived from our records and any updates that we needed from Uintah County records and BLM and state records.
Okay. For the board's record, this was not sent out certified mail, so there's no Exhibit Z on this one. With that, that concludes my examination. Ms. Schuster?
Division, do you have questions?
We have no questions for Mr. Schuster, no.
Board? Seeing none, Mr. McDonald?
Thank you. With that, I'll commence my examination. Mr. Babcock, again, for purposes of this record, Mr. Babcock, would you please state your name and business address?
Yes, Ken Babcock, 1401 Wincoop Street, Suite 300, Denver, Colorado, 80202.
And again, would you please state your current position with Middle Fork and how does it relate to the KJ2 unit?
Yes, I'm the geoscience supervisor for Middle Fork, so I've been involved in the development and exploration across the KJ2 unit, Red Wash, and our other acreage.
All right, I'm going to show you, hopefully you have copies of this, or if you can see it on the screen, exhibits F through J. Do you recognize these exhibits?
Yes.
Were they prepared by Middle Fork personnel with your review and input?
Yes.
Okay, turning your attention now to Exhibit F, would you please explain to the board what this shows?
Yes, this is simply showing a structure map on the top of the Mesa-verse 250-foot contour interval, and it's showing that the structure is regionally dipping to the northwest.
sorry. Turning now your attention to Exhibit G. Again, would you please explain what this shows?
Similarly, this is a structure map just on the top of the Castlegate Formation and with the same contour interval. And again, it's showing the regional structure dipping to the northwest.
Now, turning your attention to Exhibit H, would you please explain to the board what this shows?
This is going to be an isopac map going from the top of the Wasatch to the top of the Dakota Formation. And it shows that there's an average drill thickness to this interval of approximately 10,000 feet with some gradual thinning from the west to the east.
And finally, turning your attention to Exhibit I, would you please explain what this shows?
Yes, Exhibit I is showing the type logs that show the targeted zones for unit development, which are the Wasatch to Dakota, which is reflected in the type logs. We're using one type log from the KJ unit, which is the SUBW14M well to the left. And then we've also added in the type log from the red wash unit because we had just to show the penetration all the way down through the Dakota.
And that type log on the left is the type log that was used for the stratigraphic definition in the KJ2 unit agreement. Is that correct?
That is correct, yes. That's what we chose that one.
All right. And lastly, turning to Exhibit J, would you please explain what this shows?
This is showing a cross-section showing the continuity of these formations, which we just discussed, which shows the continuity, which is favorable for horizontal drilling and successful hydrocarbon recovery.
Okay, is it your expert opinion then that the targeted formations underlying the expanded unit lands geologically favor horizontal well development?
Yes.
All right. Madam Chair, that concludes my examination. Mr. Babcock?
Division, do you have questions?
Division has no questions, no.
Board, do you have questions? Mr. Church?
So on Exhibit J, where you show the red wash unit next to this unit, it shows horizontal wells. Have those recently been drilled in the red wash unit?
Yes, Rob could probably talk about those, but yeah, they were drilled, how long ago was that now? About a year and a half ago, I would say. Yes, they were drilled in the Neslet Formation of the Lower Mesa Verde.
Okay, and they look like they're very successful to you as why you're looking at also doing the horizontal wells in your unit?
Yes, we've had varied success across the area. You can see we've drilled some just to the south in Red Wash as well, QEP as well as Middle Fork.
Okay, thank you.
When was this unit formed?
2017.
Thank you. Board, do you have any further questions? Back to you, Mr. McDonald.
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Zabek. Mr. Zabek, would you please again state your name and business address for the record for purposes of this cause?
Yep, Rob Zabek, 1401 Wine Street, Suite 300, Denver, Colorado, 80204.
And again, your current position with Middle Fork, and how does it relate to the KJ2 unit?
Reservoir manager over all of our assets, which includes our assets here in G&B and Red Wash and KJ.
All right, I'm going to show you what have been marked as Exhibits K and L. For purposes of this cause, do you recognize these exhibits?
I do.
Were they prepared by you or Middle Fork personnel with your review and input?
Yes.
Okay, turning your attention to Exhibit K, would you please explain again what this shows and its significance to this hearing?
Yep. Again, we're looking at rate transient analysis done in Harmony. On the bottom right, you can see we used a well that we have produced, so a well that was drilled by Middle Fork Energy Uintah. History matching that well with all of our geologic inputs from Ken, and then looking at what that means from a drainage expectation ellipse. And so on the left, we're looking at that same well, just more in plan view there, where we could see the well drilled, what the drainage comes out of Harmony, and so you can see with the half length, roughly 300-foot fracture half length that we see from the Harmony modeling, which ends up with a 350-foot drainage area after 5 years. So with a 460-foot setback, you're still 130 feet off of the unit boundary from a drainage standpoint, and then 340 feet off north-south. So you're continuing to protect relative rights with that spacing.
All right, now turning your attention to Exhibit L, would you please explain what this shows?
Yes, I know at the request of the division, this is what several other operators have done, and so just wanted to put this in there to kind of support what we've done on the RTA side. But basically, we're taking same inputs I just talked about for the RTA piece. You can see fracture half length 300 feet, same permeability, porosity, viscosity, total compressibility. Putting in this calculation for Hales and Evers, and then looking at drainage time after 10 years versus the 5 that I'd run out in Harmony. But you can see very consistent results with what we saw on the side of Harmony. We showed 131 feet off east-west, and here we're showing 114 feet off. And so, you know, after 10 more years, you're seeing that difference there. So very consistent across both methodologies. The one thing I will note, you're 260 feet off north-south versus the 340 feet. One thing Hales Evers does not take into account is our high stress anisotropy. So it's a little bit more going to be more radial flow there. And so that's just a slight difference in methodologies, but still consistent, protects relative rights across both methodologies with our spacing.
All right, are there other factors that involved in your development that justify suspension within the unit?
Yeah, I mean, the 460-foot setback allows us to do multi-well pads, so continue to build larger pad development, which with the restraints in the cage area, we do have a lot of topography, and then you have some cactus and other environmental concerns that we have to also take into account. So doing multi-well pads allows us to develop this area more efficiently.
All right, is it your expert opinion that the 460-foot setback from the unit boundaries and uncommitted tracks, if it ever becomes applicable, would be protective of correlative rights of adjacent owners without waste?
Yes.
Is it also your expert opinion that suspension of the general well siting rules allows middle fork flexibility to optimize placement of wells for resource recovery while minimizing surface impact?
Yes.
With that, Madam Chair, that concludes my examination. Mr. Zabak?
Division.
No questions from the division.
Board, do you have questions?
Yeah, I do. Okay.
Mr. Walker.
Again, are you expecting predominantly gas and condensate production from these wells?
Yes, same. This is actually a little bit drier gas. So I said, you know, we're kind of 15, 20 barrels per million down in Wasatch Valley. This is more, we average 8 barrels per million in the Mesa Verde here. And then going down into the Blackhawk, it actually drops down to below that.
Okay. And I think from the last request for agency action, we expressed our concerns about the setback being overly conservative. So we'll certainly want to hear about that in the future, your other plans.
Yeah, and you can see this one is 200 feet tighter. We're at 460 versus 660. That's just because we have more data here. And so the data supports doing that here. Down south, we just don't have the data yet.
Yeah, thank you.
Has Middle Fork maintained the drilling requirement to keep this unit from automatically contracting?
Yes, we are currently in the secondary term of our unit with our continuous operations. We amended the unit agreement in 2021 to amend those continuous development requirements, and we are operating within those requirements to keep the unit in full effect.
Thank you.
Yes.
Board, any further questions? Back to you, Mr. McDonald.
Thank you, Madam Chair. That concludes our presentation in chief. At this time, I would move for admission of Exhibits A as supplemented and Exhibits B through L inclusive.
So admitted. Thank you.
Again,
No objections from the division.
Oh, I'm sorry. So admitted.
All right, thank you. And now reserve my conclusory remarks until the division's made its statement.
Division.
Yes, thank you. Again, based on the RAA submitted and reviewing of the exhibits and the testimony heard today, the division has no opposition to this request for agency action.
Thank you. Board. He's trying to keep me on task.
I knew what he was doing.
Mr. McDonald.
Thank you. Again, all the statutory and regulatory requirements for the request to be granted have been satisfied. It's a very simple matter of just extending an existing order to expanded lands here. Again, we appreciate the board allowing Mr. Babcock and Mr. Zabek to participate virtually, and also the IT department for making that possible. And we would ask that you approve the request as submitted.
Thank you. Board, do we need to deliberate? Are we ready to do a motion? Can I get a motion from someone?
Do it. I move we approve the request for agency action as submitted.
Thank you. Second?
Second.
It's been moved and seconded. Can I hear all in favor?
Aye.
Any opposed? Motion carries. Mr. McDonald, if you would prepare the order, please.
I will, Madam Chair, and I'll submit it to Board and Division Council before submitting to the board. Thank you.
This is kind of an aside, and I haven't confirmed it, but it looks to me like School and Institutional Trust Land Administration has modified their name to Trust Lands Administration. I noticed their letterhead has changed, 3 words. So, and I want to thank you for including a mineral ownership map. Much appreciated. Thank you.
Took your advice to heart.
Thank you. Exactly. Okay, I think we'll take a 10-minute break here and be back at just before 1:45. Thank you. We're off record.
1.
We are back on the record. We are moving on to what is docketed on everyone's agenda as item number 4. Docket number 2025-044, cause number 199-10. In the matter of the request for agency action pursuant to Utah Administrative Code R 649-2-4 of Perchetti Energy Holdings LLC for an order replacing Arb Energy Utah LLC as operator with Perchetti Energy Holdings LLC DBA Elevation Energy Ops. We have several motions that have been filed in this matter. And before we commence, I would like to remind everyone that this hearing is limited to whether or not the board has jurisdiction on this matter. And so we are going to commence with well, let's do appearance of counsel first. Can we do that?
Sure, I'll go first, Madam Chair. Mitch Mayo of Lear & Lear PLC on behalf of the petitioner, Perchetti Energy Holdings, DBA, Elevation Energy Ops.
Thanks.
And good morning, everyone. Oh, sorry. Peter Donaldson and Tyler Cahoon with the law firm Dentons, Durham, Jones, Pinniger. We're here for Arb Energy Utah, LLC.
Thank you. And division?
Yeah, Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Back to you, Mr. Mayo, for presenting for Perchetti.
I'm happy to do so. You know, typical procedure, the movant argues or presents their case first, and since we're here on Arb's motion to dismiss, I just want to make sure the board is comfortable with me proceeding first. I'm happy to do so.
We can go ahead and proceed with Arb if that's...
Happy to.
Thank you, Mr. Mayo, and thank you, board members and Madam Chair. My name's Peter Donaldson, as I said. With me is Tyler Cahoon. We do represent Arb Energy Utah LLC in this matter, and we appreciate the opportunity to address the board in connection with our motion to dismiss filed in response to the request for agency action that was submitted by Perchetti Energy Holdings LLC. And I'll just use Perchetti for short. First and foremost, I do want to be conscientious of the time we spend here on this issue. Counsel for the board had indicated previously that we would be limited to discussion of this pending motion to dismiss the jurisdictional issue, specifically whether the board properly has jurisdiction to address the issues raised by Perchetti in the request for agency action. And I understand that technically there is no time limit on the presentations today. And because of this, I did have and do have some concern that there might be a temptation on the part of the petitioner to get into substantive allegations in the request and in the proposed amended request due to the ongoing disputes and the emotion that is behind them. I ask that we would focus today on the narrow threshold issue at hand that really would not be informed by that type of discussion. We're here to simply determine whether the applicable administrative rules confer jurisdiction for this body to hear the dispute that's been brought forward in the request and in the proposed amended request, specifically the issue of removal of Arb Energy Utah LLC as an operator. The substantive allegations as to what Arb Energy Utah LLC supposedly has done, or the alleged reasons why it should or should not continue to operate, that's really not at issue today, and should not be entertained in the interest of efficiency and in focusing on the critical, and I call it threshold legal issue, because if there is no subject matter jurisdiction, that really ends the discussion before this body. The board will recall that Perchetti and Arb Energy Utah LLC have had an ongoing dispute for years. They haven't been able to resolve this. One component of this is that Perchetti, after receiving working interest from Arb and promising to enter into a JOA, a joint operating agreement with Arb Energy Utah LLC, has never done so. Another component of this dispute is the issue of working interest payments that came before the board in a separate action, has been ruled upon. That's been finalized before the board. Following that, the parties have discussed at various times the possibility of reaching an agreed upon resolution to all or some of their disputes, both in Utah and other places like Texas. And in the course of that, Perchetti has filed several actions against Arb Energy Utah LLC, both in Utah and Texas. From our perspective, those are designed to increase Perchetti's leverage in the larger dispute. And the instant action that was brought, we think, is another one of those steps to try and increase that leverage. So the request gets filed, and immediately there's sort of an order that comes out from the board setting an evidentiary hearing. We got involved late. We hadn't been engaged in working with ARB immediately prior to that, and we were engaged and came on and looked at the issues, and we saw that jurisdiction was not appropriate. So in our first filing, we submitted a motion to dismiss based on the jurisdictional issue. And in response to that, we have not seen any grounds as to why this board would have jurisdiction. Also, as part of all of that, we then received, and in the action, a response was filed to the petition by the division, the Utah Division of Oil, Gas, and Mining, the division, and that also recommends dismissal. And I thought it would be helpful to I have copies of that response. It's very short and simple, and I'd like to be able to pass those out to this group and to council.
That's fine.
And in many ways, I believe the division said it better than I could have. I'd be happy to let Mr. Haynes speak to it. I don't want to mischaracterize anything that he said, or that the division said. Sorry, that he was the author, but this is the attorney, this is legal counsel, Assistant Attorney General, and the Attorney General on behalf of the division. But I just point to a few things in this response. Very first page, about halfway down, the division does not believe the petitioner's relief can be granted under Utah Administrative Code R649-2-4. That's designation of operator section, and the board cannot grant the petitioner's requested relief without adjudicating property and contractual rights, which is beyond the board's delegated authority. And that is the rule that was cited. That's the only rule that we've seen cited. If you go to page 2, it quotes that rule at the bottom of page 2. And this is after there's been kind of some setup as to the structure of the regulatory scheme in this brief that was submitted by the Assistant Attorney General, the Utah Attorney General's office. If you go down to the bottom, it talks about this rule 649-2-4, paren 3, which does provide, it says at the bottom, provides a mechanism to which an owner may challenge the designation of an operator, quote, provided that no challenge may be asserted after the protest period specified in subsection R 649-3-4 has elapsed, and then it talks about the possibility of this board, or of the division, excuse me, shortening that 10-day time period, and preparation for drilling has commenced. So that's kind of the key, is the statutory scheme, that is the regulatory scheme, the administrative rules, provide for a request for agency action to challenge the appointment of an operator and to seek the removal of an operator, but it's in a very short time period at the very beginning. And once preparation for drilling has commenced, that's the end. And in this case, we're well beyond that, in that drilling commenced in 1986, and then in 2019, this is in our motion to dismiss and the exhibits, Arb Energy Utah LLC comes onto the scene and steps into the shoes as that operator. And then Mr. Perchetti obtains, Perchetti, the company owned by Mr. Perchetti, but Perchetti obtains an interest, working interest, in 2021. So long ago and well past the windows, or the window that is contemplated under the rule to actually bring the action that is now being brought. Now, it is possible for an operator to request a change of operator, as noted in this brief, kind of in the middle of page 3. And when you go down into the argument, kind of at the beginning, I think this sentence is pretty critical. The division is cautious to weigh in on issues that may affect or seek to declare correlative rights of owners. And we're talking about contract issues, property rights, right? Those are court-type issues. In this instance, the division is pointing out, and again, it's a little unusual to speak on, Mr. Haynes' behalf in a way, or as to his brief, but it is correct. A, the request for relief cannot be made through the cited rule. B, an operator change can only be approved by the division when there's a recognized transfer of property. And C, the board's authority does not extend to adjudicating property and contractual rights raised in the request for agency action. And so the division recommends that the petitioner resolve any property and contractual issues in district court before proceeding with a request to the board. And then if you go to page 4, also pertinent, right in the middle of that, there's a sentence that says the division is unaware of any authority granted to the board that would allow them to order the transfer of ownership of an asset from an operator to another party without consent or a court order. And that was our read as well on the law. That's what our research showed. There isn't any authority for that. And then, of course, there is some discussion on the top of page 5 about some of the things that are implicated in the request for agency action. And by the way, I would submit, I know there's a motion to amend and a proposed request for agency action, but the defects are the same, in that the rights sought to be adjudicated are contractual rights, property rights, and so forth, joint operating agreements, and so forth. And as I mentioned, Mr. Perchetti has not, or his company has not signed a JOA. And so it goes on to talk about, those are implicated in this dispute on the top of page 6. It talks about how the board would have to review the agreements and the facts to determine if a breach of contract has occurred. And there's a citation to the law on this, which is essentially that there are enabling statutes that give this board its authority to adjudicate certain types of adjudications, and anything outside of that is not appropriate. So in regard to regulating oil and gas operations, powers to enforce regulations, but not power to determine property rights or to interpret contracts among private parties. And it notes at the bottom of page 6, the courts, with their routine use of discovery and rigorous application of the rules of evidence, are better suited to hear and resolve disputes over contracts and rights to property. And again, therefore, the division recommends that the issue be dismissed until we have a determination from the court. And so that's the sum of it. Fairly simple, fairly straightforward. You've got your rule-based framework, and then you've got sort of the passing of time. And the administrative rules do not allow a working interest owner to wait and see how an operator performs and then launch a removal action before the board if a payment dispute arises years later. That would undermine regulatory certainty and the orderly administration of operations. So the regulatory scheme embodies a limited window to contest an by agency action and then operator's appointment or an operator's continuing operations at the commencement of operations, not years after the fact, based on the whim of a single working interest owner. The dispute Perchetti has with ARB Energy Utah LLC is a private dispute, and the rules that control this body and what this body can hear and decide are limited, or that is, those rules limit the circumstances and the window for a challenge to the appointment of an operator or the continuing operations of an operator under a request for agency action. If those rules were not so limited, this body potentially would be flooded with requests to remove operators anytime there was a dispute between an operator and any other party. There'd be no limit. So we would submit that the request for agency action, the proposed amended request, both of those do not fall within this limited subject matter jurisdiction that has been conferred on the board for the reasons that the division set forth. And for those reasons, dismissal today is the appropriate action with respect to this dispute. I recognize that doesn't resolve the larger dispute between Perchetti and ARB Energy Utah LLC, and that's just going to have to be dealt with separately. But we have to do the right thing with what's before us now, and there's nothing in either the request for agency action or the amended request submitted by Perchetti that alleges enough or that would allow the board to hear the issues that are being raised, specifically whether ARB Energy Utah LLC should be removed as an operator and the contractual and property rights that need to be adjudicated or that would need to be adjudicated to make that determination. So for those reasons, ARB Energy Utah LLC requests that this action be dismissed.
Thank you, Mr. Donaldson. Division, do you have any follow-up to that?
The division does have comments on this. I don't know if now is the proper time you would like us to make it. I mean, we didn't file an objection to the motion to dismiss. The petitioner did. Our response was limited to the initial request for agency action, but we're happy to proceed however you would like.
I think we'd like you to go ahead and respond.
Okay, sounds good. Yeah, so I think most of what was in our response, that was a good summary there, and gives you an overview of the way the division, I guess, analyzed this specific request. And I just want to make that clear is that was our duty. Here we got a request for an agency action and we wanted to look at it. And I just want to remind you the request for agency action that we were responding to, the actual ask was that petition was asking that the board replace ARB as operator for 76 mineral leases in Grand and Uintah counties. And so that's what we were responding to. As was indicated, the response came, the request was made under the authority of R649-2-4, which is our designation of operator rule. And the way we read that rule is it was time limited, as we've talked about. You can only bring that rule prior to the finalization of an APD. There's been some discussion in the response by the petitioner that they believe that there's an expansion of how that could be interpreted. The division's response to that is there has to be a stopgap in that rule. An operator could come along and ask to, a new party could come along and ask to remove an operator, and then a year later we could be doing the same thing. There has to be some consistency in how the board recognizes who an operator is in a unit and a well to encourage development, to encourage expenditure of capital, and it just makes sense. And so we don't feel that there's any other interpretation of that statute, of that rule. The division has a rule to change operator. It's our change of operator rule, which is found in R649-3-1, subsection 14.5. In that case, an operator, they can come along and they can, when there's been a transfer of property, that's the language used in the rule, they can file to have a change of operator. That change of operator needs to be endorsed by both parties. Petitioner was not able to do that in this case. For whatever reasons, ARB was unwilling to agree to a change in operator, and so here we are. So the division didn't feel like you could replace an operator under the designation of operator rule. They didn't feel like petitioner met the requirement to change operator under our change of operator rule. So what was left? Well, the board has broad powers. I'm sorry, my thing keeps cutting out. 40-6-11-3 provides the board the ability to grant grant orders. Sorry, let me just bring this up really quick. Actually, could I use that? I'm going to switch microphones. Thank you. Okay, thank you. So the board has broad powers under the statute granting the board authority of oil and gas matters. We're told whenever it appears that a person is violating this chapter or a rule or order made under the authority of this chapter, the board may issue an order requiring compliance within a period not to exceed 45 days. We have some case law on this rule as well. The Sullivan case indicated that to enact an order of compliance, it must first appear that a provision is being violated before the board can exercise its discretion in deciding whether to issue an order compelling compliance. So again, the division, if we didn't have the designation of operator rule was going to help, the change of operator wasn't going to help, what rule was being violated here that would help the petitioner with its request? The division isn't aware of what rule is being violated. It wasn't pointed out in the request. We didn't we weren't able to interpret how else an operator could be changed. So, but what we do have in the request is we have numerous discussions on JOA violations. And the JOA, as it says there, typically a JOA designates an operator, describes the operator's authority, and provides for recourse if a party defaults on its obligations in oil and gas. So that's what we had to go by in the request. We were provided one JOA. I believe it was Exhibit B. That JOA, just like all JOAs, has provisions that talk about how you remove an operator and how you designate an operator. That every JOA can be slightly different. There's multiple different recognized AAPL forms of JOAs. The specific one they provided indicates that an operator may be removed if it fails or refuses to carry out its duties. If we wanted to recognize whether the petitioner's actions were in compliance with the JOA, we'd have to look at every JOA. We'd have to look at the terms of that JOA. And I'm willing to bet in each instance, ARB would say that they believe that they were complying with the duties. I don't want to make anybody's arguments here. The point I'm trying to bring up is that there would be a legitimate contract dispute in each and every JOA. So how do we resolve legitimate contract disputes? There has to be an adjudicatory hearing. There has to be a hearing on a breach of contract, possibly have a declaratory judgment on who is right, who is wrong. So can the board do that? That's why we're here. I have up there the Constitution of Utah. The district court shall have original jurisdiction in all matters except as limited by this Constitution. So Utah courts have subject matter jurisdiction over all legal claims unless adjudicative authority for that claim is specifically delegated to an administrative agency. And if we want to know if it's been delegated, we look to the plain language of the applicable statute. In the recognition that the board has broad powers when it comes to regulating operations of oil and gas, the division is unaware of any provision that would give them the power to adjudicate contractual disputes. For this reason, the division filed their response, and in this situation, for this specific RAA, the division does not feel that the board could request the relief granted. That's all we have.
Thank you. Then I think we'll move on to Mr. Mayo for his presentation.
Thank you, Madam Chair. As was noted, the motion is ARB's. Just to remind everyone here, Mitch Mayo of Lear & Lear on behalf of the petitioner, Perchetti Energy Holdings in this case. As ARB noted correctly, they filed the motion to dismiss, but I think, it sounds like an insult, but I agree with Mr. Donaldson. I think the division did a better job of laying out the jurisdictional concerns. And so I'll focus on the division's response and discussion much as ARB did in this. At the outset, let me be clear. As a practitioner before this board, I'm well aware of the limitations of this board and of the fact that there are certain issues that are better suited for certain venues. I'm open to that.
Could you move the mic closer, please? Thank you.
Yes, I will. But I'd like to remind everyone at the outset, there is only one body in this state that's tasked with regulating oil and gas development in Utah. And there's only one body in this state that has access to teams of geologists, engineers, lawyers, and staff to regulate oil and gas activities in Utah. There's only one body in the state comprised of experts in fields adjacent to oil and gas development. And there's only one body in the state that has both the ability to set the rules for development and the ability to enforce the rules for development. Not even the courts have that. And whether you like it or not, this board, you all, are that one body in the state that can do this. And so I'd like to have that kind of as the the beginning point. My short answer to the question today, does this board have jurisdiction? Absolutely. The longer answer takes a little bit of time. One thing I'd like to note, both Mr. Donaldson and Mr. Haynes, I think, made slight misstatements, both in their briefing and here in presentation. They both discussed whether the rules conveyed jurisdiction. I think Mr. Donaldson said, we're here to determine whether the board's rules confer jurisdiction on the board. But clearly, first-year law students know that's not how jurisdiction is conferred. Only the legislature, only the statutes can confer jurisdiction. And so we have to look in detail at the Utah Oil and Gas Conservation Act. And specifically, we have to look at what it is they tasked you all with doing and what it is they tasked and funded and staffed the division to be able to do. And so I'd like to walk through that, if I could, really quickly. By examining the language in the Act fully, I think we'll all have a better understanding of what jurisdiction exists. Starting off with 40-6-1, the public interest statement of the statute. There is a declaration that it is in the public interest, quote, to authorize and to provide for the operation and development of oil and gas properties in such a manner that the correlative rights of all owners will be fully protected. Now, the correlative rights are defined in statute as the right of each owner to produce his or her just and equitable share of the pool. Mr. Perchetti is, by definition, an owner, having purchased, not received, having purchased a 25% interest in these leases 5 years ago. He is an owner. And this board, the legislature said, has the obligation to authorize and make sure that Perchetti has an equal opportunity to produce his equitable and just share of the pool, as does ARB, another owner. Moving on to 40-6-2, specifically subparts 1A and subpart 2. This states that the regulation of, and I quote again, all activity associated with the exploration, development, production, processing, and transportation of oil and gas as set forth in the Oil and Gas Conservation Act, quote, is of statewide concern, and the state regulation, i.e. this board's regulation, of oil and gas activity occupies the whole field of potential regulation. Now, nothing in that, to me, sounds limiting. Nothing in that, to me, says there are things better done by other people. That says to me this board is tasked by the legislature to regulate the whole field of oil and gas. 40-6-9. We're well aware of that, especially the parties in this matter. 40-6-9. It requires someone like ARB, the designated operator of a well, to pay, quote, any person entitled to the payment of oil and gas proceeds from the sale of production within a specified time. Further, it gives this board express authority to adjudicate a request for agency action requesting payment and an accounting, including a review of the same JOAs, and to penalize an operator when it determines non-payment was not justified. Two more citations. 40-6-11. The statute goes on and it provides the division and the board with, as has been mentioned here today, not only the authority to enforce the act, but the tools and mechanisms to do so. It includes the power to summon witnesses, which has unfortunately had to have been exercised in this instance against ARB in the prior matter. The right to compel testimony, again, used against ARB in the first matter when they wouldn't appear at the hearing. Levy administrative penalties for noncompliance with both board rules and orders of this board. And ultimately, 40-6-11 provides the board and division with the power to strip an operator of its right to operate a well or wells for unabated noncompliance with board orders and rules until that compliance is corrected. And finally, 40-6-5. the legislature saw fit to give this board, in addition to all those very clear understandings of what it is they wanted them to do, what it is they wanted you to do, they said, quote, the board has jurisdiction over all persons and all property necessary to do what it is we've tasked you to do. And so I'd like to start there. Everything that I just discussed from the statute is the legislature's decision. It is what we are stuck with, and it is what confers jurisdiction upon this board. And also, nothing in what I said, to me, sounds like the legislature would like you to limit what it is you do with oil and gas. I think what they would like is for you to occupy the whole field of regulation and enforce your statute, your rules and orders with the tools they've given you. And so, to rehash, it's in the public interest for Perchetti Energy Holdings to be able to have the opportunity to produce his just and equitable share of the pool. He's prevented from doing so because of what's happening. The Act requires ARB, as the designated operator currently, to pay proceeds timely and properly. Clearly, that's not something that's been happening. The Act also closed the division and the board with the authority to regulate, as I said, the whole field of potential regulation. And that includes operatorship. And finally, and most importantly, it endows the board with jurisdiction over everything you would need to enforce it. Now, clearly I'm of the position that this board has authority to make decisions related to oil and gas. And the instant RAA invokes this jurisdiction. Now, both parties, again, the respondent, ARB, and, or I should say the movant, I'm not sure whether a response has been filed, but the movant, ARB, and the division in their response, they both focus on, and I think rightfully so from the way the pleading was presented, the rule R649-2-4, and whether that rule clearly conveys jurisdiction to this board. As we've discussed, that's not relevant to jurisdiction. The question is that the appropriate rule under which the board can exercise its jurisdiction if it chooses to do so?
Mr. Mayor, excuse me for interrupting. Have you made any of these arguments in writing for our review?
That the statutes
All
confer
these
jurisdiction?
statute quotes and everything?
We didn't. I mean, honestly, I got retained about 3 days ago to help with the argument.
Just a question. A lot of quotes going on here.
There's a lot of quotes, and I'm happy to pull up the statutes, and we can look at them as we go through them. I thought to save time, it would be easier since, I'm assuming.
Please go ahead.
Yeah, thank you. No, the question is whether this board has jurisdiction. All we need to do is look at the statutes for that, and it's clear when you look at the statutes, the board has jurisdiction. Now, there's a second question, and that is whether the board should choose to exercise its jurisdiction. And that's not one that I necessarily have an opinion on, except in my opinion. I don't have a legal basis to say, yes, you should, and here's why. I have a practical basis to say, yes, you should, and here's why. But what the parties who've responded in writing, as Madam Chair said, have focused on is Rule 649-2-4, and a very strict reading of what it is they think that rule says. And again, since the division said it better, I'll probably focus on how the division said it. The division's response, not a motion to dismiss, just a response suggesting that it believed dismissal might be appropriate. The division makes two main points, and I'd like to focus on those. First, the division says it, quote, does not believe the petitioner's relief can be granted under 649-2-4. And second, it says, quote, the board can't grant the petitioner's relief on property and contractual issues. And so I'd like to go through those. With respect to 649-2-4, I just simply disagree with the reading of the plain language of that regulation. And what I think happened, at least in the division's response, is I think the division was, kind of intuiting the context in which that rule was promulgated. Those of us who were involved and around when that rule was promulgated understand that as overlapping drilling units were starting to become the norm, and operator A may have the right to propose and drill a vertical well, and operator B may have the right and opportunity to drill a horizontal well covering the same lands, If both submitted APDs to the division, it caused a problem for the division because they didn't know whose APD to look at first, how to approve them. And so that regulation was largely promulgated to address exactly that, the dispute over operatorship at the outset of drilling a well. But if you look at the plain language of 649.24, which doesn't include that context, I don't agree that it is limited to that. And here's what I'll say. The regulation says any owner who wants to bring a challenge to this board for any good faith reason can do so, asking them to change the operator. Now, this board has there's a lot of concern from everyone that if you decide to say, yes, we have jurisdiction to consider this, that every single person who has an interest in a well will suddenly file a request and you'll be flooded with RAAs. I would suggest that's not the case. And here's why. Because I've always read this rule this way. The parties interpreting the rule as limiting a designation of operator change to only a situation when an APD is approved, that's the new interpretation for me as a practitioner. And what I'd like to do is kind of dovetail into the division's second position, which is that you can't really get into this because it's contractual and property disputes. Everything we do in oil and gas touches on property. Every single pooling hearing involves the application, imposition, evaluation by this board of a JOA. If this board and the division are only able to do things when they're not opposed, then it really isn't an adjudicative board anymore. It's just a stamping board. And I don't think that's what this board is meant to be. I don't think that's what the division is meant to be. And based on these 2 points, right, the rule doesn't expressly allow it, and we can't possibly wade into issues that touch on contracts or property. Based on that, the division states its belief, and this is where kind of the crux comes down. The division states its belief that the division and board, you all have incredibly limited authority when it comes to operators. You can accept that they're the operator when they tell you they are at the beginning, and you can also accept that they're resigning as operator when they tell you at the end. But you have no ability to remove a bad actor who is operating. That, to me, is the most problematic read I could have from these rules as a citizen of the state of Utah. I believe this board's job is to look at what it is that causes problems and benefits for oil and gas, and to minimize the problems and increase the benefits of oil and gas development in Utah. And I think the truth is, and everyone who's been involved in oil and gas for years has seen, bad actors do exist. They are out there. They will do whatever they can until someone forces them to stop. Now, I'm not supposing that's ARB. I'm not supposing it's anyone. But I think this board needs to be really cautious before it says, we will never step in to remove an operator. And that's what they're asking you to do today. They're asking you to say, you don't have the ability to do this. Now, it is entirely proper, as I said, for this board to say, we recognize we have the authority to do this, but we choose not to do that. That's okay. But it's not okay, in my opinion, for the board to say, the legislature does not allow us to do this. And that's where I think the difference comes in. Now, there's been a lot made, and Madam Chair made a good point. What in the request really helps us get what you're saying here today, right? The request and the amended request, the opposition to the motion to dismiss, none of that says what you're saying here today. So how did that help us? It's entirely fair. And it happens in court all the time. You know, if you plead a case in a certain way, but it actually falls under a different type of statute, it's entirely appropriate for the court to amend that, to give the parties a chance to respond, and to say, let's evaluate it under the proper context. And that's, I think, what would be appropriate here. And given that the next available hearing, if the board is inclined to accept jurisdiction, is in October, we've got plenty of time to put a clean request in that clarifies, and they've got plenty of time to respond and prepare. And so there isn't an issue with that. But I'd like to know what is in the request. there is, in the initial request for agency action, the non-amended, but the initial request for agency action, there is a reference to 649.24. There is clearly a regulatory hook. But there is also, on the front page and the second page, a listing of a litany of board rules and board orders that have not been complied with. One that isn't speculative, that doesn't require a hearing, one that this board knows full well has never been complied with, and that's the order in 19905. Almost a year since the board determined that ARB owed Perchetti Energy Holdings nearly $1 million in proceeds of production that it had never paid, and I note that ARB said on the record they don't have the money for. After they misappropriated his $1 million in proceeds of production, the board gave them until November 26, 2024 to pay. Not a penny. And so this board needs to think long and hard about whether it wants operators to be able to come in, drag a years-long process out, get an order from the board, and simply decide they're not interested in complying with it. And if that's the case, I'm not sure what point the royalty accounting statutes really serve any longer. Because if they're only for good actors to comply with, how do we deal with the bad actors? And so I don't want to belabor it. I think I've covered everything, but I'd like this board to really seriously consider its role as the state's regulatory body, its role as the policy-making body for oil and gas, and kind of what can happen. This board is well equipped to evaluate 5 REAs a month that request this and say, no, we don't want to hear those 3, but these 2, yeah, we should. That's not beyond this board, and it's certainly not beyond the division. And any work in evaluating the provisions of the JOA that the division may take, I'd just like to remind everyone, they did that exact same thing last year under the royalty accounting statute with these exact same JOAs that ARB finally and reluctantly supplied. And on that, I'd ask this board to assume jurisdiction and set a evidentiary hearing for the October docket. Thank you.
Is it your position that a Utah district court cannot resolve this issue on contractual and property disputes?
No, I'm actually really glad you brought that up. And Mr. Haynes is the one that showed it. If the board needs to see the text of it again, I'd ask him to bring up that constitutional provision, if you would. But what it says, and I think it's important, and this is maybe me talking past and to the attorneys on either side, but what it says is it says the district court has jurisdiction over all these things unless it is expressly and specifically delegated to an adjudicative body. And so there is no question, there's no dispute from me, and I don't think anyone else, that both, well, there is a dispute. I believe both the board and the courts have jurisdiction over this.
So can you point to any specific statute that gives this board authority to resolve this contractual dispute? We've talked in a lot of generalities and things, but is there a specific statute?
Respectfully, I'd like to push back and say this is not a contract dispute. This is a dispute that undoubtedly touches on a contract. But this is not a contract dispute. This is not us coming in and saying, you charge us costs on our gas gathering system and they're based on these deductions and we think, that's not what we're talking about. This is the simplest of the provisions in a JOA.
But, go ahead.
No. To the point, I think the entirety of the Oil and Gas Conservation Act says it is your job to adjudicate disputes that impact the public health, safety, and welfare. And if an operator who, by the way, it's important when you're considering a motion to dismiss, especially a board like this, it's important to look at the allegations that are contained in everything. And if you see the allegations, it's entirely appropriate for this board. This board's job, as I see it, tasked by the legislature, is to prevent environmental harm and to prevent really bad things from happening because of oil and gas development. It's my opinion that what we're watching is a slow car crash. And the question, what everyone's trying to tell you is, yes, once the car crashes, you have authority. You go in and you can pick up all the pieces you want. But you'd better not try and put the brakes on. And that to me seems like, I'm not sure what the board's role would be. I don't see the board as sweeping up after bad things happen. I don't see the division as simply being a glorified filing cabinet for self-certifications of operators. I think these agencies have done a very good job of regulating the oil and gas industry, not by avoiding tough questions. I don't think, I guess to respond to your question maybe more obliquely, I don't see anything in the Conservation Act that says you can't look at this. And I think that to me is more important because it gives you the clear ability to set rules, to enforce those rules that cover the entirety of oil and gas regulation. You've set rules and you've tried to enforce them simply because they didn't agree. You still have grounds to say, remember that order we made last year? You've been in open and continuous violation of that for a year. That alone gives us jurisdiction to evaluate whether you should be an operator. If this was S.L.M minerals, if this was BLM minerals, or excuse me, if this was TLA minerals, if this was BLM minerals, if this was minerals of a large mineral owner family that were not being paid, I cannot believe the board would come down on the same decision the same way. I don't think there's anything in the statutes that say you can't or shouldn't look at this. And I think the Conservation Act clearly says you are created solely to do this kind of work.
So if district court can resolve contractual property issues, could the relief sought in this matter come from a district court?
Absolutely. And you know, Mr. Donaldson pointed out, it's not for lack of trying, right? They couch it as a business dispute and as, you know, the guy who got his money stolen from them is hunting them in some way. But the truth is, it's simply trying to pursue in every venue possible, in every way possible, what is absolutely fair and just. And it turns out this group of people right here has full authority from the legislature to determine what is just and to do that. And I think they should. Regardless, though, to kind of focus on your question, there is always with administrative matters a question of when you file in district court, the exhaustion of administrative remedies. And it's unclear, there's no case law as to whether this has to be brought before the board. Clearly everyone here says there's no jurisdiction. But for those of us looking at the statute and reading it a different way, that exhaustion of administrative remedies would be necessary. So to get to your point specifically, this board has the authority to take jurisdiction. It has the authority to deny, to take the matter, and either way, the district court will have the ability to review that decision or make a decision also.
Thank you.
Yeah.
Before we do rebuttal, board, do you have any questions for the witness? Mr. Donaldson, shall we go back to you for any sort of rebuttal that you might have to Mr.?
Sure, I'll try to be brief. Madam Chair is correct. Most of the arguments that we just heard were not briefed, which, you know, that has its own set of problems. But I think fundamentally we can't ignore the remedy, the relief that's actually being requested, and the basis for that. I've heard counsel admit that these issues are properly before the district court. I've heard a question, and I listened very intently. Is there an express delegation of contractual and property rights and removal of an operator in this type of proceeding? And, you know, there's an attempt to kind of stretch the statute or the rule, excuse me, that says, you know, any person may challenge. But that was the whole problem from the beginning. Any person may challenge, provided that they're in this window, and that's not here. So silence about the issue is not enough. When the district court has jurisdiction, which we know it does, there has to be an express delegation. And we just don't have that here. So all that means, though, it doesn't mean the dispute's resolved or the dispute is over. It just means that this body, this board, doesn't have the jurisdiction to hear this particular dispute, the remedy that's being sought, and the issue that's being raised, which is the continued status as operator, removal of operator, and the bases for that. Yes, he did council pointed to specific provisions allowing this board to adjudicate payment disputes. There's no question about that. That's happened. And that is being dealt with in the ordinary course through the enforcement means. But we don't believe it is appropriate to, quote unquote, pursue every venue possible. I mean, I guess in theory, if you don't ask, the answer is no. And so it's another possible venue. Maybe we go back to the board and we ask that the operator be removed as a way to get paid, which is obviously what's going on, even though there's a final order on the payment issue. And so I don't think that's appropriate. And again, if the rule were otherwise, if the board viewed it otherwise or acted otherwise other than dismissing, it does open the door to this type of dispute, this type of request, anytime there is a dispute with a single party of any kind. So we think the division's position was very clear in the division's brief, and I haven't heard anything today or seen anything in the briefing that would change that. Again, that's not to say that there isn't or wouldn't be a remedy. In fact, just the opposite. And I think the board can take comfort knowing that there is a consensus that the district court can hear and decide this. And we would submit that, again, the board does not have jurisdiction, and even if it did, it would be better on balance to have the district court hear this type of dispute with the complexity and so forth that goes into it. But you don't even get there because we know that you have to have an express delegation of authority, and we don't have that. And where there has been express delegations, yes, there's jurisdiction over all the people and all the contracts at issue in those situations, like a payment dispute. But that's not the case here. And so this particular request and the amended request that seek the remedy that they seek of not just removal of the operator, but replacement of the operator with Perchetti's own company that's already been representing to people that they're the successor operator and that is soliciting my client's employees. That's just not appropriate for this board, for this body. And we have to kind of follow, not just kind of, we have to follow the rules and the law. And so nothing that I've heard and nothing that we've seen would change the division's position, our position that this particular action should be dismissed at this time.
Thank you. Mr. Haynes, do you have any comments?
Sure, just a couple of quick comments. Mr. Mayor quoted a lot of provisions. I can't say if they're out of context or not because I don't have them in writing. But we did hear a lot about operations, activity, development. That is the board's jurisdiction, without a doubt. But that's not why we're here. Because we're here about what fundamentally comes down to. There are contracts in place, and there's avenues to enforce those contracts. I didn't hear anywhere where the board's jurisdiction extends to adjudication of contractual matters. I still am unclear what statute or rule the board would even be acting upon if they were to hear this matter. And that's the problem. That's why the division does not have support of this, because we need to be able to point to something concrete and say, yes, you're in violation of that. We heard about that the board can suspend operations for violations. I think it was even stated that you can remove an operator. That's news to me because I don't know where that is in the statute. But yeah, you can suspend operations for violations once a party reaches max penalty. But there's a process for that. 40-6-11(3) allows us to remove a bad operator. As opposed to what Mr. Mayor said, you do have authority to remove a bad operator. Because what is a bad operator? It's a party that's not following the rules. And once they don't follow the rules, that's why the division is here. We issue NOVs, we issue DEOs, we fine them. And when they hit a point where they are not in compliance, we suspend them. Don't think that you don't have that power, because it's there. The problem is, again, what is this request being brought under? And it's completely unclear to the division outside of a contractual dispute. And if it's a contractual dispute that involves two parties with a legitimate contract, question of contract, we're still unaware where the board is given that authority to make that decision. Thanks.
Thank you. Mr. Mayhew. It's getting close to lunch.
No, I understand.
Do you have any final comments?
I do, and just a couple quick ones. I think it's a fair point, right? I didn't pull up the statutes while I was going through them with the board, but hopefully after years of practice before this board, there's a little bit of trust that I say what is true and I mean it. Also, I'll be here next month. If the board finds that I was misrepresenting, feel free to hold me my feet to the fire. That being said, a couple quick things. Mr. Haynes pointed to, listen, we can remove a bad actor. All we need to do is follow 40-6-11, which allows us to do that, and the regulations we implemented to do just that. The problem is it requires the division to do something, and the division chose not to for some reason in this case. And so suddenly that prohibits my client from being able to have this board's relief. In fact, 40-6-11, and I'm happy to pull this up if we'd like to follow, what it says is, if the division determines that a rule is being violated, and this is paraphrasing, not quoting, if the division determines that a rule is being violated, it shall issue an NOV and a penalty to ensure compliance. And after a certain number of days, when $200,000 as a total penalty has accrued, then you can remove the operator. Now, at the end of the October hearing, last year, in the unrelated cause 199-05, the board concluded that they had been violating 40-6-9, not a rule, but a statute. The board also concluded they were violating a rule. And the board gave ARB 90 days to cure. They didn't, and they made clear on the record they had no money to cure. At that point in time, the division had every bit of information it needed to follow 40-6-11. And just because it chose not to, it's now coming in and saying, but they can't get your relief now because we didn't do what we were supposed to do. This is a bad actor. This is a bad actor in this very specific context. This board doesn't need to wonder if they're violating any rules. It doesn't need to wonder if they're respecting the board's orders. It knows firsthand the answer to both of those. And so if the answer is, had the division properly done its job, you would have an avenue of relief with this board, but because the division chose not to follow 40-6-11, you don't get relief. That seems to me incredibly problematic. And so I'd just like to leave you with that one last thought, and that is, everyone keeps making a point about contract disputes. Courts undoubtedly have better expertise than you all in discovery, in hearsay objections, no question. How many JOAs do you think a district court judge has looked at? How much context do you think a district judge will have as to what impact this can have, not just on my client, but on oil and gas development for the state? That's this board's job, and I ask you to do it here today. Thank you.
Thank you. Board, do you have questions? Mr. Moon?
Yeah, just clarify a little bit what you were saying, what the division could have done. So after we made the judgment for the, whatever it was, $800,000.
$830,000 to be exact.
And they didn't pay, and they acknowledged they can't pay. What could the division have done there?
can I steal your plug-in thing? Oh, yeah. I'm just going to pull up the statute if you want. We can walk through it because I'm not terribly prepared to go through that in detail, but also because I don't want to upset Andrew again.
I would appreciate seeing this too.
Thank you. So 40-6-11, right? This is a statute that is in effect. It gives this board the authority to, as it says, assess penalties, enforce the rules, etc. And as we go through, if it's okay, since I'm not prepared to point, let's go to 3A, and we'll just jump to that. Whenever it appears that a person, and the rules clarify that a person is a company for purposes of these rules, so we're talking about ARB. Whenever it appears that
Madam Chair, and just in general, I have to interpose an objection here. Maybe you're going to allow this, maybe you're not, but the concern I have is this really doesn't go to the threshold issue. In other words, what could happen or what might happen, and it's an understandable question, Mr. Moon. It really is. I do understand that question. Of course, I'm asking myself the same things. We all are. My concern, though, is it's getting outside of the actual issue at hand, which is the jurisdiction of this board to hear the requests and the proposed amended request for agency action as an agency action proceeding. What the board could or could not do, and then what would result from that, is a separate question. And I don't think it's helpful. I don't think it advances the ball to get into that. And I just have to object. It's not relevant. It doesn't go to the issue that's at hand.
Can I ask the question? So, but if there is something where the division could have done something, that does go to the same question. Can we do something? Is it within our jurisdiction? That's why I'm asking that question, because yeah.
Can I answer that? I do think it's an understandable question, and it's in kind of an alternate universe. If the division had done this or that, would the board then have jurisdiction to adjudicate it? There's an answer to that. And if the answer is yes, you would have jurisdiction in that instance, but that's not this instance. So I'm just going to stand on the objection. I'll let you treat it how you wish, but that's my issue.
I'm going to overrule it and let you proceed on this one issue, but let's keep it narrow.
I will do my best, and I'd just like to, for the board's sake and Mr. Moon's sake, I'd like to remind everyone involved that the board can choose which rules of evidence it wants to follow as part of this hearing, because it's designed to be a public hearing. 40-6-11, to answer your question, in 3A, that really says it, right? Whenever it appears that a person, ARB in this instance, is violating this chapter, the Conservation Act, or a rule that this board has promulgated, or an order from this board that's made under the authority of this chapter, the board can issue an order requiring compliance within 45 days. Seems pretty straightforward. That's what happened in the 19905 matter. At the August hearing of last year, the board determined that ARB was violating a rule and had no justifiable reason. The board then said, you have to cure it within 90 days. They didn't. If we go down to the other part of 11, it's essentially, and I'm going to, at the risk of encountering another objection and violating Madam Chair's request to me to keep it brief, I'd like to say that council can probably review all of these and give you a really good understanding of what it does and doesn't allow. But as I read it, it essentially says the division then can assess penalties in a certain amount. That amount is based on a penalty table. It's based on all sorts of different factors, and it's every day. Once you've gotten to $200,000 in penalties that haven't been paid, and step in if I misstate, then the division can take the next step. And what I said was strip an operator of the right, not remove them. And I do think that's maybe my read on it, but it does say you can shut in their operations unless and until they cure. And ARB was made clear they can't cure, and they have no intention of curing. So it's effectively a removal because the wells can't be unoperated. So 40-6-11, the truth is, it's, despite what ARB wants you to believe, it is really all we should be discussing is the act and what the legislature believes is necessary for this board to look at. So it essentially gives the division if it's known and proven that there's a violation, the ability to penalize and then escalate that.
Ms. Sierra?
So as I'm reading the division's response here, there's a quote here that says, as such, the division recommends the issue be dismissed until a determination is made by a Utah District Court as to what rights and obligations the petitioner and ARB currently hold in each well in disputes under the JOA. Perchetti has not signed the JOA, if I understand correctly. We made that ruling last year regarding the penalties. The question is to the division, does it matter in this specific case with jurisdiction for us to rule if Perchetti did not sign the JOA?
Well, that goes back to who wants to decide if the JOA is applicable or not. I don't have the exact information on every JOA and how they applied. The RAA talks about JOAs applying to the wells. We have to take that on face value in our response. So that's what we responded to. If there's questions as to whether that JOA actually applies or not, that's a whole nother matter. That's a whole nother question.
If I may jump in and add some context from last year's proceedings, ARB was subpoenaed, not once but twice, to produce the documents necessary to do an accounting, and they failed to do so, as you can see in the order if you review it, adequately. But what they did do is they supplied 30 JOAs that they said govern. This board is not a court. You don't have to follow the formalistic rules of a court. What you need to do is use common sense and your experience as oil and gas regulators to say something is wrong here. And if we don't act, this not only damages the person sitting in front of us, but it sets an incredibly bad precedent.
You can't take two bites of the apple. You can't say a JOA applies and we followed it, we're operator, and then say the JOA doesn't apply because we didn't sign it.
We have never taken the position that it doesn't apply. We have always taken the position. And the truth is, whether we take the position or not, the law says we are bound by those JOAs because we took an interest from them. They would like us to negotiate a new JOA. Have never sent one. Not in the time I've ever been involved. Haven't attempted to negotiate one since I've been involved in the last 3 years. But that's the position. Perchetti has never argued that the JOAs didn't apply. His position has consistently, and if you go back through the last hearing, you will see these JOAs apply. They finally provided them and said, fine, these apply. And now the argument is whether, because we're a signet, it simply doesn't matter.
Mr. Moon.
So, Mr. Haynes, do you think a district court would actually remove an operator? I would think a district court would kick it back to the Division of Oil, Gas, and Mining
Sure.
You know.
The question isn't, are they going to remove the operator? The question is, what does the contract say? And are you in breach of contract? So
not non-payment of a judgment is in breach of something. I'm not an attorney. They did not pay for 5 or 6 years.
Yeah, and
they were found to be in whatever the legal term is. But we said pay, and they've said we can't, and I don't know if they're even trying. And so I don't need to look at a JOA to figure out whether they should pay or not. We know they should have paid. They didn't, and we said pay, and they haven't. So. Yeah, so it just seems like we're trying to kick the can somewhere, and we have the ability to change operatorship. It just seems, I don't know. I'm just
sure.
I'm frustrated.
And I think we're talking about two different issues here, right? We're talking about a prior matter where the board, we went through the proper procedures, we followed the statute. You issued an order. That order then, I believe, was not, I can't speak to this because I haven't been a party to this, so someone will probably correct me. The order was not followed through, and now that order, or at least enforcement of that order, is in district court?
As I understand it, they're pursuing district court enforcement. The division and board were both requested under the rules to do so, as is their obligation, and both declined. So we had no choice but to pursue that ourselves.
So we have two cases actually going on. The payment of royalties is separate from the question we're talking about today.
Well, and to be totally clear, the payment of royalties issue is not in this board's
Right.
jurisdiction anymore. That is in
That's
the
gone.
court's jurisdiction. However, that order covered proceeds from 2020, January 2020 through 2024, April.
Right.
No judgment has been made. No determination has been made about royalties paid in the last 18 months. And what I can tell you is, if this board believes that suddenly they refused to pay the judgment, but they started paying royalties properly, then I would say that's a mistake.
But that doesn't affect what we're talking about today.
No, and that's what I'm trying to say is, you're bringing up an issue that I don't want to touch.
Okay.
But if there's been a subsequent violation of payment of royalties, you have mechanisms.
So
Well,
we
and
can add them up again and tell them to pay again.
But I also would like to remind everyone, it's not just a violation of the rules. It's also a violation of this board's order. This board ordered ARB to pay by November 26th, and they did not. That alone ends the discussion. We don't need to look at any rules. The legislature said you have the right to do a royalty accounting and make orders and enforce them. And if they ignore you, you have the right to enforce them by all persons and all property necessary to do so. I just don't know what else you could have for a specific delegation than that.
May I respond?
Sure, Mr. Donaldson.
Because I'm hearing you can't do anything about that anymore. The district court has it on one hand, and then he comes back and says, well, that's really what this is, or you could do it here. That's just not right. We are getting away from what has been asked, what the
Right.
issue is with this request. If there's an issue of payment in the last 18 months, then we know how that looks. We know what that type of request
that's a
would
separate
look
issue.
like. That's
Madam-
a separate issue.
Yeah.
And that's the issue that we have is I did bristle that, I understand. And if I were sitting in your shoes, this might appeal to me because I'm a human being just like you. You should use your common sense. Ignore the law and use your common sense. That's not appropriate. We do follow the rules, and again, nothing's changed the fundamental issues that the division has raised, and whatever the division may or may not do, that's a separate issue. We have to look at what's actually in front of the board, and there isn't jurisdiction for those questions. There could or might be for other questions.
Thank you.
Madam Chair, I wonder if it would benefit anyone to just have someone on the board ask ARB's representatives if they've complied in any way with the order from last year, and that might help us resolve a bunch of the questions that are.
Mr. Moon asked a question, and what I can say is that we have tried. We've made substantial offers. The problem is there is a larger dispute going on, has to do with the JOA, has to do with other transactions, has to do with interference with fundraising that would actually get Perchetti paid or would make it much easier, and we haven't been able to resolve those. So, I mean, and again, that's actually not relevant either, but it's a question that's out there.
We're going to wait till we resolve our business stuff to do what you ask us to do, board, and then we'll get back to following your rules.
Yeah.
We're just talking about the process.
I would like to go back to our initial, what is the limit of board's jurisdiction in this matter, contractor jurisdiction in this matter, and leave royalties as a separate issue.
Yeah.
Do we have any other questions? Mr. Galecki?
I do. So part of the order is to remove, if I'm following it, is to remove ARB as the operator. So what does that do in the case if he's removed?
Well, it does the same thing that the legislature saw fit to do in 40-6-11, and that's say you don't get to keep operating if you're not going to follow the rules. Stop until you come into compliance. It seems common sense. And again, it's not saying avoid the law and only pay attention to common sense. It's saying, well, the law makes a lot of common sense. That someone who's continuing to violate the regulatory bodies, the only regulatory body's rules, shouldn't be allowed to continue doing that activity in the state. It's a no-brainer. And so I think you bring up a good point, Mr. Galecki. This is really a two-step request, right? Everyone's like, they want to replace, yes, ultimately. But what they're trying to do is responsibly manage this oil field in the absence of a responsible operator, right? The first step is removing ARB as operator. And I think undoubtedly, clearly, the board has the authority to do that, especially if the division had taken the step that it should have probably in assessing administrative penalties. That being said, that didn't happen. But removing ARB, as the division even acknowledged, this board has the authority to remove a bad actor operator. So that's step one. The second step is, what do you do with all these 125 wells that have been around for 40 plus years and have no active operator? And it's, again, this board's responsibility to manage them responsibly. And it seems to me that not just some working interest owner, but someone who owns a 25% interest in the well and has fought for years to get this project back on its feet is a pretty reasonable alternative. And so it is a two-step process, right? But whether the board has jurisdiction, the statutes are crystal clear.
And so is ARB currently operating within the state and in good standing?
I mean, technically, the division hasn't accepted yet a signed resignation of operatorship, and according to the division, that's the only possibility for them to not be the operator anymore, so yes.
It looks to me like Section I is talking about violations of operations and not necessarily violations under the JOA. And so I guess I'm having trouble forcing those two together, that we're talking about operations and we're talking about JOA contract.
JOA contract, there could be some dispute. We know they had some JOA disputes and getting signed, et cetera, but non-payment of no payment to a 25% owner, we determined that was a violation and said pay up. So, we keep bringing in this contract thing, but isn't the question really, have there been violations? Does that make sense?
Well, currently, there aren't any violations with the division.
As far as operations.
Right, everything.
Even as to royalty payments,
What's that?
we've had complaints on royalty payments within the division.
Yeah, there have been three requests for agency action filed by other mineral owners.
Are those not violations?
They've been resolved.
Well, and I'd like to clarify, back to where Madam Garrison started this, 4I, which I believe is what you're looking at and referencing there on the screen, 40-6-11,
right.
4I. If you look at 4A, which kind of sets the stage for 4I, the list, it says if the board or division, if either of you determine after an adjudicative proceeding, which happened last August and last October, if either of you determine that ARB has violated a law, a rule, or your order, assess penalties. The division didn't do it. That's okay. The division cannot accept administrative penalties on behalf of the state, but that decision in no way can impact the relief that my client is entitled to from this board. I'd also like to point out, just briefly, at the risk of shooting myself, Mr. Moon keeps bringing up a good point, and Ms. Garrison does as well. This is about a JOA. We don't have the ability. Isn't this really about a JOA? I'd like to remind the board, there are rules that this very board promulgated that say, let's say in a compulsory pooling context, I propose a well, you don't like the JOA, you propose alternative provisions, guess what happens? The parties come in here, and both of them argue their preferred JOA provision. This board is tasked with determining and imposing the JOA provision that it believes is best. We're not asking for interpretation. This is apply the JOA that they finally said applies. apply the terms of that to determine whether they should be allowed to continue to take the money from this well and do whatever they want with it.
Can you point to any specific rule that states the board can remove the operator?
There are rules. Well, before answering, I'd like to give you a silly answer, and that's that the rules don't say lots of things that this board can do. So the rules are created by this board and division typically in response to a need. And I think this case presents a very clear need, right? That there should be something very explicit about operators being removed. That being said, the whole point in the penalizing scheme, in both 40-6-11 and in the regulations that were promulgated, the whole point is to ensure compliance by all means necessary. And I cannot envision that at the end of that, if they really, really, really refuse to comply, that you just let them keep operating. So I think it's safe to assume that the board can remove an operator based on the entire enforcement scheme that's established.
Thank you. Yep. Mr. Donaldson, do you have any final sort of closing comments?
The main comment is going back to what we said at the beginning, which is we need to focus on what is in the actual request and the amended request. And I don't think anything here has changed the fundamental analysis that the division put forward and that we put forward, that this particular action should be dismissed. I think looking at the statute, that's a bit of a red herring. It talks about the division, or the board, excuse me, filing suit. It does talk about the possibility of penalties. The board has decided what it decided, and we're working through that. We're going to have to deal with that, and we will. But what you really can see is that there is a larger dispute, and that this was an attempt to pull another lever to get more leverage, but it's not appropriate. We are a nation of laws and procedures and process and due process, and in this particular instance, this action needs to be dismissed because the jurisdiction just isn't there for the subject matter, for what's requested in that request.
Thank you. Mr. Haynes, do you have any closing thoughts?
I got a lot, but I'll just limit.
How long will that take?
Not very long. There's been some discussion in here that the division did not act on this prior order that we've heard. I believe what Mr. Mayor is referring to is under board rules, after there is an order, the board or the division can go enforce those orders in civil court. The board never directed the division to do this. The board never acted on this. Based on the, I would say, sophistication of the parties, we're out talking about two working interest owners. I don't feel that was a needed use of state resources. So we did not feel any need to do that. So I just want to bring that up because I don't want anyone out there to think that the division just didn't do something, because they take their jobs very seriously. We have a lot of people back there, and when it comes to enforcing these rules and making sure operations and development are being done, they like to make sure they're done properly. That aside, I would just go back to there's a lot in the statute. I read it all the time. Without something to point to bring an action before this board, we cannot enforce it. We cannot act. We cannot just say, just because we don't like something, we're going to do it. And I am not aware of any provision in our rules that will allow us to remove an operator. We can suspend their operations until they are in compliance, but we cannot just tell them to go away unless they're in violation.
Mr. Mayo, oh.
Just a quick question.
Go ahead.
So if we don't have the authority to, how would a district court could, though you say, remove the operator and appoint a new one?
Because
we can't?
Because it's a contractual issue. These two parties have a contract.
Okay.
You breach your contract, then there's consequences. And under the contract, it tells you how you can become the operator. It spells it out. You need to vote. You need to have parties vote. You need to meet those requirements. The court will look and say, did you meet that requirement? If you did, you are now the operator. If you didn't, you're not the operator anymore. That's how. That's
You're
how
saying
that
they
happens.
could. They just go through the JOAs and
Yeah.
interpret them.
And once that has been recognized, come back. The division will recognize your change of operatorship because you now have shown that there's been a transfer of property that allows you to operate those wells.
And is not non-payment of joint interest owner payments, is that a violation of the JOAs? Like, does it even discuss that? In
I've never seen a JOA that doesn't require payment to people entitled to
to
payment.
pay.
So I'm not sure what kind of argument you could even make.
So why did you and your client decide to come here first?
I didn't. They did.
Okay.
But I can see why they did, right? If you think that I'm being creative for creative's sake, then this case should be dismissed. If you think that you've got two sets of attorneys, both smart, both zealous, trying to advocate for their clients, who read these statutes differently, then you can understand my client had no choice but to make sure that he had exhausted administrative remedies, because despite pursuing what's right for 4 or 5 years in various jurisdictions, somehow has been unable to, as our counsel keeps putting it, figure everything out. We haven't been able to come to the big resolution that whatever it is that's out there, but we don't really care. I don't care about that. I'd like to, before I go any further, just address something Mr. Haynes said. I have the ultimate respect for division staff and counsel. The job they do is overwhelmingly large, and they do it exceptionally well. That being said, I think I'm good at my job, and I make mistakes all the time. And the truth is, Mr. Haynes said during this hearing, board, don't let anyone fool you. You have the ability to remove an operator. And now he says, but our rules don't really allow it. They allow us to hold them back for a while. I disagree. What's up on the screen says clear as day. They've been violating your order. If the division decided that it wasn't worth state resources to defend your orders in court, I understand that. It makes perfect sense to me. And I think it's fair to say the parties have the ability to do it, so why should we as the state? That makes sense. But that decision can't foreclose legal rights for my client. If so, you're going to get a lot of really aggressive requests from the division and board to do what it is the rules say to the letter, or else clients will lose those rights.
Board, do you have any further questions? Mr. Galecki.
So we had an order. The order was, the order wasn't followed. We talked about another mechanism being, what's the next step? Either violations. Is this the appropriate next lever, as they said, from a petitioner, that when it wasn't followed, you come back?
I'm not sure that I know the appropriate lever to get a bad actor to do the right thing. I've never found it in my 20 years of being a lawyer, and I'm not sure that this board and all its creativity and wisdom is going to come up with something, the magic bullet that's going to make ARB suddenly do the fundamental thing that operators do, and that's pay what they get out to the people who are owed. So I don't know that I necessarily think this is the best next lever, but I do think, clearly based on my argument today, I do think this is a lever that's available. And more importantly, I think this board needs to think not so much about the contract, not so much about my client or ARB, but they need to think about this board's authority. If you are a police officer and you say, stop, and someone keeps walking, you have to decide whether they get to decide to keep walking or whether you get to decide they stop. And like it or not, you guys are the police of the oil and gas world in Utah. And you have told them in no uncertain terms, stop. You penalized them 5%, you assessed interest, and they still haven't done anything. And it's your decision whether you want to make them stop or just say, we tried. Good luck in district court. And 6 years from now, when this massive tangle of business dispute is finally resolved, then we'll step in and help you clear this problem up. But until then, there's allegations that their assets are being shut down by other regulatory bodies. This board should be very attentive to this request.
Can I just step in? This is a completely different matter. We are not talking about the old matter.
at all.
Well-
We are talking about the violation of your order.
And I think even if they were removed as operator and Perchetti took over, it would not resolve the revenue issue.
But the
'Cause
idea
that still is a separate
the
issue.
idea that they're seeking to remove ARB just because of what we heard, I mean, that's a whole nother discussion.
Right.
And I haven't been told that. I haven't been told that this is their
Right.
their procedure. All I know at this point is Perchetti wishes to operate those wells, and he's a working interest owner.
Well, I mean, on paper, he hasn't received any of the benefits or protections of being a working interest owner, but he paid value for, he is of record.
Do we have any further board questions? Any further comments from either of the presenters here? Mr. Donaldson?
The only thing I would say is, again, everything from the discussion, one thing that's clear, the dispute can and will be resolved, the larger dispute. We're not talking about the old case, but yet that's what we've been talking about the whole
Right.
time. It can and will be resolved in court or by agreement, and this petition, the amended petition, the removal of operator is not appropriate at this time.
Thank you. Division, do you have any closing? Okay.
I don't want to go around again.
Thank you. This is it. Mr. Mayo.
I will try not to do anything substantive. What I will say is, rarely does the board get the opportunity to have discussions like this and make decisions like this. It's important to not think about what's expedient, what's easy. It's important to think about what this board's role is and what you want this board's role to be in Utah oil and gas. And I'd like to thank the board for the attention and thoughtful questions, and the division for their really appropriate response and argument here today. Thank you.
Agree.
Thank you. We're going to conclude this matter, and I think the board will need to discuss it among ourselves. And so we are going to break for lunch and discussion, and we'll be back at 1 o'clock.
Thank you.
Thank you.
1.
We are back on the record, and we have deliberated on this matter. Can I have an order or a motion?
I make a motion that the board grant ARB's motion to dismiss for the reasons outlined in the division's written response to the request for agency action.
Do I hear a second?
I second.
All in favor, please say aye.
Aye.
Any opposed? No. We have, I guess we'll do a roll call. We'll start here with Mr. Galecki.
Aye.
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 So we have 1 no and 6 yeses, so the motion passes.
Perfect. And Madam Chair, who would you like to prepare this order? Is this
We
board
will
counsel?
have our prepare the order,
Thank you.
and I believe that, yeah, I believe that concludes this matter. Mr. Haynes, I do have something for you, however.
Okay.
Under 40-6-11 sub 4, the board directs the division to bring an action against ARB for potential violation of the board's prior order regarding payment of proceeds. The board would like to hold the hearing on this matter in October.
Could you kind of restate what you want again there? You want us to bring an action for failure to pay?
They have not paid what the board ordered, that $830,000.
Okay.
The board has the ability to levy fines and penalties, and we're enforcing that.
Okay.
That issue.
All right. All right. Thank you.
Thank you.
And to be clear, you're saying a new action to enforce the prior
Right. The
action's
board
decision.
under 40-6-11-4, the board has the ability, if our orders are not complied with, we had an order ordering ARB to pay Perchetti $830,000, whatever the exact figure was, that has not been complied with. It hasn't happened. And the board has the ability to levy up to $5,000 a day in fines for up to, isn't there a time limit or?
5,000 a day, or if willful, 10,000 a day, up to some amount, 200,000 maybe.
Up to a set amount. And we'd like that brought at the October meeting. Will that give you time to prepare?
There's some nuances in there, but I'll work with board counsel to get exactly what you guys want.
Great.
If it takes them a little while longer, the board can waive the filing requirement by filing September 10th. We're all aware of what's coming. We'll have time to prepare, so.
Okay.
Oh, yeah.
Well, we would request time to prepare in the ordinary course. There's no reason to unduly expedite it. If it happened to be, October, great. If that's how it shakes out. But we had a lot of concern in this case because, okay, even though it's past the 10th, you're going to be having a trial next month. That's too much. That's not the way the system works. We're supposed to have due process. We may have legal issues depending on how it looks. We may have a motion to dismiss depending on how it looks. I understand the impulse, but we have to have process.
Division, could you do your filing by the September deadline?
I would love to tell you yes and can try my best. It's going to be really tight, though. There's a lot going on. But yes, we'll try.
Okay. Thank you. That will give you time before the October hearing to prepare any information that you might need.
In fairness, it shouldn't take long for anyone to prepare, yes, we paid, or no, we didn't. So it should be pretty easy to prepare for what it's worth.
Yeah. All right. Thank you. That concludes the Perchetti ARP matter. We have one more docket item, and we're going to trade board council positions here. Mr. Carter Moore is going to sit in for Mr. White, who is sitting in for the unknown permanent counsel. Good to see you.
Good to see you, Madam Chair.
All right.
Ready?
I think so. Hold on just a second here.
Are you ready?
Okay, Madam Chair, I think I'm ready. Thank
Okay.
you.
This is docket number 2025-036, cause number 997-05, in the matter of formal rulemaking to adopt R 647-1, definitions 647-2, exploration mine 647-3, small mines, and R 647-4, large mines. We're back to you, Mr. White.
Thank you, Madam Chair. Assistant Attorney General Gary White on behalf of the Division of Oil, Gas, and Mining. And seated next to me is Wayne Western, the Minerals Manager for the division.
Thank you.
We are here today to finalize the I think, years-long process of updating the minerals rules. We were before the board 2 months ago, and we presented the substantive changes to the rules. You'll remember we had a presentation, and the board ordered at that time that the proposed rules be sent to the Office of Administrative Rulemaking. That has now taken place. There is a public comment period that's allowed during the 30 days that it's with the Office of Administrative Rules. So we're here today to do two things. First, we will present to the board the comments we received and the division's responses to those comments. I'm hopeful the board agrees that they are not substantive and that we can go forward. Assuming the board agrees, we will then ask the board to adopt the updated minerals rules with an effective date of today's date. So that's just a little roadmap of what we hope to do today.
Thank you.
Would you like me to proceed?
Yes, please.
Okay. So we had two comments. The first comment that we'll review came from, and let me make sure I get this right. This came from the Utah Physicians for a Healthy Environment. The first comment that was submitted by, I'll just call them Utah Physicians. They had some concern about the small mine rules using a different word for revision than the large mine rules. They felt like that there was some confusion there. The reason that the small mine rules use the word amendment in its rule and a different word is used in the large mine rules is because in the small mine arena there is no distinction between amendments and revisions. Everything is just an amendment. And that's because small mines don't have a public comment period. So I think that the Utah Physicians thought that this was actually a discrepancy, but it's actually a difference in verbiage because the small mine rules are different than the large mine rules. So that's a summary and an explanation regarding the first comment. I'm happy to take questions from the board if it has any. Okay, we'll move on. The next comment from Utah Physicians was the Utah Physicians were concerned that the updated large mine rules regarding revisions and amendments don't differentiate between unincorporated areas of the state versus incorporated areas, and that the rules didn't distinguish between different county types, so a rural county versus a more urban area of the state. We looked at this very carefully, and after review of the rules and after looking at what the division's done for the last at least 2 or 3 decades, there has never been differentiation between how the rules are applied in urban versus rural parts of the state. There is a differentiation for unincorporated and incorporated areas, but that only goes as to whether a mine is considered a small or a large mine. So for example, a mine that's 10 acres in an incorporated area, if it's more than 10 acres, it becomes a large mine. But in rural areas, it's 20 acres or more to be considered a large mine. So Mr. Western may have some comments, but reviewing this comment from Utah Physicians, we did not see any reason to change the rules because mining laws have never been regulated that way in the state. So if there are any questions, we're happy to answer those.
When people make comments, do you write back to them, or do you just put the comments on your comment sheet and assume they'll go out and look at it?
The comments are just posted, and the division receives those. And today was their opportunity to come and discuss their comments.
Okay.
But based on what we saw earlier, it doesn't seem like anyone has appeared.
Thank you.
I have a question, please. So,
yeah.
With your comment period, and maybe you discussed this in the last time we presented this, but have you any inputs, comments, endorsement from from the Utah Mining Association?
Great question. We have provided these updated rules to them numerous times. Natasha Baliff went through this last time we were before the board. I don't want to misstate, but there were multiple opportunities for UMA to weigh in, as well as stakeholders and large mines. We received no comments or objections from any of those groups, despite diligently providing them the updated rules.
Thank you.
Thank you.
So I have a question about how does this relate county by county or urban by non-urban relative to zoning that is in place or zoning that is offered after a permit has been granted?
I'm going to answer the first part, and then I'll let Mr. Western supplement my answer in case I get it wrong. But the basic premise is that the minerals rules they apply equally statewide. There is no differentiation based on area of the state or county. The only exception would be whether a mine is small or large under the rules, and that is the 10 acres for incorporated versus 20 acres for unincorporated. But these rules have always been applied equally throughout the state. Now, as to zoning and how that works, I'll let Mr. Western talk about that.
We don't do anything specific on zoning. It's up to the counties and cities to have those zoning ordinances in it. And in order for someone to mine, the area would have to be zoned for mining use. So a city could zone, have a zoning exclusion for mines, for example. I don't, people call me up a lot and ask me about mineral rights, and I say, well, I own the surface, but I don't own the minerals. It doesn't bother me because somebody just can't walk in and start digging up my front yard because it's not zoned, the area's not zoned for mining. So zoning is a local government issue, and that the mine operator is responsible for making sure that they have the proper zoning permits before they commence mining.
So does the division actually look at the zoning first before they determine to grant a permit?
We are not required to check to make sure that the area is zoned. It's not our responsibility to make sure that everything with the zoning, the ownership, and that is in place. We generally try and do a cursory look to make sure that the person does have the right to enter the property. With most things being online, it's relatively easy for us to do kind of a cursory look, make sure that they have the proper permit, proper zoning, and also the ownership for that. Occasionally we will find that the person may own the surface, but they do not own the minerals, and then we'll inform them. but there's nothing specific within the rules that says if you do not have all of your permits, we cannot grant the mine permit.
Thank you.
Yes, I have one other question, and I'm just trying to understand the process really. So as part of your stakeholder engagement, is it just posting the rules in the paper or the necessary publications, or do you actually have an outreach where you seek to go out and contact like key stakeholders about, hey, here's a heads up, here's what we're doing? I'm just trying to understand the process.
No, it's a great question. No, there is specific outreach. We specifically provided these updated rules to key stakeholders like Utah Mining Association. And I'm remembering that when we were before the board in 2024, some of you were on the board at that time, and you'll remember that we went back after an initial hearing, and that's when the board committee was formed to assist in preparing these rules. But in the 2024 timeframe, we did have meetings with Utah Mining Association, and I recall at least one stakeholder. But for this go around in 2025, we specifically provided the rules and did not receive objection or comment.
That's a good overview. Thank you.
The only other thing I would say in response to Mr. Church's question is that nothing about the updated rules changes the procedure regarding local zoning. Nothing has changed in this update. Okay, so moving on, there are two, that's all the comments we were, oh, excuse me. There's one additional comment from Utah Physicians. The comment had to do with whether these rules would affect what is considered regulated by the division and what's unregulated. There seems to be a misunderstanding that somehow the updates to the rules will change what's regulated. For example, rock and gravel would be the example, sand and gravel. Thank you. There is no change in what the division regulates based on these rules. Of course, that change would need to come from the legislature through a statute. So nothing in these rules has somehow given the division more authority to regulate or taken away any authority. These rules don't touch that issue. So that was the final comment from Utah Physicians.
So just to clarify on that,
yeah.
Wayne, my understanding has been if they're blasting into hard rock, then it's mining, then we have jurisdiction. If they're just taking surface gravel pits, say,
right,
and crushing, this size rocks into smaller rocks, then we don't get involved. Is that right?
Correct.
Okay.
Yeah, so there is specific exemptions for sand and gravel operations, and a few others, basalt operations less than 50 acres, and some other exemptions, but everything else we do regulate.
And then, quick question on that Parley's Canyon, I forget the name of it, Tree something?
Tree Farm?
Tree Farm. Has anything happened up there? Did they get any, because we were the first step, and we said okay after all the hubbub. Did they ever make any progress up there? Or?
As far as the division's aware, they're still working through that with the county.
Okay.
Is that your understanding?
Yes.
Yeah.
And were there some changes particular to that? It seemed like there was something with that where we realized, and were there some changes that were created or because of the size? I think they started as a small mine and then went to a large mine. And were there any changes that we found because of that?
The thing that they started out requesting a small mine, and then they were planning to immediately go to a large mine, and we said, no, you're planning on you should be applying for a large mine. And then we got into the revision versus amendment. So then it went out to public comment. Oh, one other thing, with the minerals program, of course we do not regulate coal. That's a separate entity. But basically, like I said, it's mostly sand and gravel that we don't, as far as mining goes.
Okay, thank you. That concludes our response to Utah physicians, and there's two other comments, unless there's a question.
No,
Madam
go ahead.
Chair? Okay. The second set of comments came from an individual named Justin Wild. It was just presented in email format. The first comment from Mr. Wild, he had some concerns that the Office of Administrative Rules form referenced a Title 40-6 as granting authority. That was just simply a typo. The actual language of the rules that we're asking that the board adopt today have the correct reference to 40-8. So it was simply a typo. We've ensured that that's correct. That's corrected. And it was just actually an administrative form that had the typo, not the rules itself. And then the final concern from Mr. Wild had to do with an updated definition regarding what would be included in a mine. There's language in the updated rules about non-contiguous mining, and the updated rule indicates that non-contiguous mining will be considered one operation if it's within a 2-mile radius. This commenter was concerned that that may cause some issues in the future. I'll rely on Mr. Western to talk about this a little bit, but before I do, I would just point out to the board that it's been division policy to consider a non-contiguous mine that's within this 2-mile radius since at least 1990. So it's actually been the written policy of the division for 35 years. It's just now making its way into the rule as part of the update. So the legal point that I would make is that nothing will change as to the way the division is administering small mines with this update. But Mr. Western can talk more about the reasons.
Okay. One of the key reasons, the way that the rules were written in the past, is that small mines at one time were exempt from being bonded, particularly those that were under 2 acres. And so what people were afraid of or concerned was that you would have an operator come in, establish a mine here, then go over a little ways, establish a mine here, establish a mine here, in order to skirt around the bonding requirements. Since then, all mines, regardless of size, are required to post a reclamation bond. In the past, we did have a written policy. It was signed by Diane Nelson back in January 2nd, 1990, that gave a definition that if the 2 operations were within 2 miles of each other, then they would be considered one operation and would be covered under one permit. The way that the rules are stated now, it's vague, and to avoid regulator roulette where we would have 2 different leads and in good conscience might come up with 2 very different definitions of what is close by, we've decided to just take the existing policy and place it into rule. I do have a copy of the existing policy here if anybody would like to take a look at it.
Are there any questions about Mr. Wild's comments? Okay, then with that, we would ask the board to formally adopt the minerals rules update with an effective date of August 27th, 2025, today's date.
Do I have a motion from the board?
I'll make a motion that we adopt the rules as presented as of today's date.
And a second? I second. It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? And I think we are formally approved.
Thank you, Madam Chair.
Congratulations.
Thank you very much. I know it's been a long process, and we appreciate all of the hard work that the board has put into it.
Thank you. I believe that's the last matter on our docket. Do I have a motion to adjourn?
So moved.
All in favor?
Aye.
What an eager group. Any opposed? Hearing none, the meeting's adjourned.
Good job, Carter.